May I?
Yes, Mr. Sawantray.
The challenging order dated, my lord, 11/27/2011, my lord.
After 12 years, what is the status?
Status, my lord,
Stay.
7 years conviction eitla. 2011.
Extra copy dele. Instruction anile. There is an order that you will serve an extra copy on the state and you will also obtain instruction. Regarding welfare of the petitioner and I mean in general, what is the possibility?
Go to it time then. Perhaps period undergone he jayithibo.
Already stay heni?
Na stay he. That is the 9/8/2011, my lord, admit heitila, LCR call for heitila.
Relation to stay hechi. Bail grant hela ni?
Nai bail grant.
कौन है था? सीधा बोधे you would have completed the sentence most likely.
Yes, ma'am. Perhaps it.
Mr. J. Samantray for the petitioner, Mr. Devashish Naik AGA for the state, Learned Counsel for the petitioner seeks accommodation, further accommodation to obtain instructions. He has served the extra copy. You have served.
Yes, I have not served.
And shall also serve extra copy of the petition as observed earlier on the Learned Counsel for the state as spread for 7th December or further time, sir?
70s.
7th December. Aji to last week he lagay. कौन अपन 7th से कौन आनी से तो खबर पाउ नांती से कहउछन ता सिचुएशन देखछु 3rd week रे रखन कि 2nd week रे रखन 15 12 से लोअर कोर्ट लॉयर के संगे भी किछि नाही
Contact नहीं.
very difficult. He must have been in jail custody when he filed the petition and
2004 रे order heitila. 2011 रे confirm hela.
हां
2011 ରୁ 2012
ବର୍ଷ ଏଠି ହେଇଗଲା.
ବର୍ଷ ହେଇଗଲା. Already period undergone perhaps ବାହାରି ଯାଇଥିବ ନ
ଦେଖ. But problem is that even I can't also observe without being sure anything. So that is the other difficulty.
Yes.
Simply if adjourning is the only, perhaps is the only way out now. Yes, please. Next.
Item 2.
Yes.
Permit to withdraw, my lord.
You're filing a memo?
No, my lord.
Please file a memo.
My
That should be on record. Apna memo file kar debe. Mention kar debe number item 2. Your name, sir?
Kuldeep Panda.
Mr. Kuldeep Panda.
On behalf of Mr.
On behalf of Mr. Manas Chan for the petitioner. So Devashish Naik AG for the state. Memo filed by the Learned Counsel for the petitioner. Indicating that the petitioner, as per the instructions received from the petitioner, he is not inclined to pursue the matter any further. Subpara, the petition stands disposed of. Yes, 3.
Item 3.
Item 3, my lord, no instructions.
Memo te diyantu.
Aye.
Then leave is yet to be granted. It is still a fresh petition.
My lord.
The CRLP has been filed under section so and so. The Learned Counsel for the petitioner submits that he has no instructions on behalf of the petitioner to prosecute the matter any further. Matter is pending as such without any leave being granted. Though it has been converted to CRLP as per the order dictated 7/11/2016 passed by this court. Memo ta dele. The memo filed on behalf of the memo filed by the Learned Counsel for the petitioner dated 22/11/20 is taken on record. The petition stands disposed of. Call the list. Mr. Manish Dhir on behalf of Mr. Sarthak Naik for the petitioner. Opposite party blank. The learned counsel for the petitioner seeks accommodation. As prayed for January.
Any date, your lordship.
January 2nd, 3rd week record दियंतु. अपन टे सबुठ अटकी के रहउचंदी जे 9/11. These matters are actually all adjourned matters. What has been listed today yesterday and today. So that they inform me that 93 matters. Specifically agenda 93 matters for 2 days.
Item 5,
Mr. Dev.
Please, my lords.
Yes.
Well, it is that matter, my lords, where your lordship wanted to know whether my prayer is maintainable or not. For a declaratory read that the
Yes, I have to declare that amount
demand is wrong.
No, it's not. It has not ended there.
Right.
A demand is made. The petitioner comes to court is one thing. Demand is made. It is debited, credited to the claimant's account.
Right.
Then you want also the reversion of that account amount.
Of that. My lords, I'm placing reliance on a judgment, my lords, of Supreme Court. Your lordship told me to just inquire whether I can get any supporting judgment or not. My lords, this ABL.
Yes, ABL International. Yes. See the facts of ABL.
But
ABL, since it is a
yes,
well-known
yes,
judgment,
I understand what your lordship is saying. But
yes.
what the
No, it's not.
principle
It's not a question of lordship saying. It's
No,
a
no.
question of my lords at Supreme Court what they are saying.
Right.
Because you see, Mr. Dey, as per your proposition, I have to interpret ABL.
Right.
Being a
Right.
High Court judge, I have to interpret ABL that yes, declaratory relief can be granted.
My lords, I'm placing it. I'm trying to convince hard, my lords. My lords, actually.
No,
And-
Mr. Dey, the greater responsibility for all of us,
Right, my lords.
including you and me. the
My
greater
lords, I'm
responsibility
placing
that
reliance of paragraph.
in this
My-
process, you were creating the impression in the, as far as the client is concerned, that something is going to happen.
Maybe. I'm not sure.
Yes, ABL International, which
My lords, paragraph 25 at page 570. Let me read
25
it.
at 570.
570.
Yes.
Let me read it, my lords. The learned counsel for the respondent then contended that though the principal prayer in the writ petition is for quashing of letters of repudiation
Yes.
by the first respondent, in fact, the writ petition is one for a money claim,
Yes.
which cannot be granted in a writ petition under Article 226 of the
Yes.
Constitution of India. That is the contents.
Hmm.
In our opinion,
Yes.
the argument of the learned counsel
Hmm.
also cannot be accepted
Hmm.
in its absolute terms. This court in the case of UP Pollution Control Board versus Canoria Industrial Limited,
Yes.
while dealing with the question of refund of money in a writ
Yes,
petition
yes.
after discussing the earlier case law
Yes.
of this subject held, that I'm emphasizing, my lords,
Yes.
in the para extracted above, in a similar situation as arising in present cases relating to the very question of refunds. While answering the said question affirmatively, this court pointed out that the courts have made distinction between those cases where a claimant approached the High Court seeking relief for obtaining refund only, and those where refund was sought as a consequential relief. They have differentiated.
No. Yes. So
After
that is not important actually. What you are reading, just read.
After
That
striking
plastic
down,
term be slowly. After striking down of the order of assessment.
order of assessment, etc.
Yes.
In these cases also, the claims are made for refund in the writ petition were consequent upon declaration of law.
In fact, in
So,
Odisha High Court,
my
there are-
main prayer, my humble submission before your lordship, my main prayer,
is it when you are
the
challenging,
demand is illegal.
you are challenging a assessment of tax.
Right.
Where you have challenged the assessment of tax on
It is
which
not
provision?
assessment of tax, my lords. It is under the contract, my lords, whatever.
So please, you are conceding there. You are conceding that this decision is against you on the
Why?
face of it.
It is not a
decision is
question
not-
of tax. it is a question by the instrumentality of state. Where
Sir, those lines don't add. If you are challenging the virus of a statute, the tax it is set aside, the demand is set aside, then what consequence will happen?
If your lordship feels it, this principle only relates to tax refund.
Yes.
If your lordship feels it,
No. I am not feeling.
What your lordship is speaking out.
This judgment is against you.
But
You see, you are adding certain lines. You are adding certain lines, words, and into the judgment, which I cannot do. For a lawyer, it is easier. Yes. Then you read further. The last paragraph, the analysis of the Supreme Court. This judgment cannot be read as laying down the law.
Exactly. In these cases also, repeatedly came where the retribution
bit slowly. Or you are just. Upon say microphone टी तोड़ू कर दियो.
Hence, this High Court committed no error in entertaining the writ.
No, that's not the finding.
Anyway, I am coming
this
to...
judgment cannot be read as laying down the law that no writ petition at all can be entertained where claim is made for only refund of money consequent upon declaration of law that levy and collection of tax /cess is unconstitutional or without authority of law. Yes, please read further. Yes.
Then, next page, my lords, paragraph 26 and 27.
Yes.
I'm relying on.
Just kindly read the last two lines. After that.
Yes.
Since you are not reading, so I have to read it. You are just stopping, reading one line, then stopping. It is yet another thing to say that such power can be exercised sparingly, depending on facts and circumstances of each case. Yes. For instance, in the cases on hand where facts are not in dispute, collection of money as cess was itself without authority of law. No case of undue enrichment was made out. And amount of cess was paid under protest. The writ petition were filed within a reasonable time. So these are the five conditions.
In that case, the referred case, actually cess was challenged.
You see, the Honorable Supreme Court.
My lords, in that referred case.
Since you are not submitting, so I have to assist you. So that is how. These are the five conditions have to be satisfied.
This referred case. Then the court, while dealing with the case at hand, ABL International, what they said.
What is you see the Whirlpool, kindly see para 28 Whirlpool.
Yes. So that I am going to read. I am also placing reliance on it.
Sir, you don't have to read that because Whirlpool principles are reiterated.
Yes.
The other day, if you kindly remember, I told you that Whirlpool principles are very clear.
Yes.
That read jurisdiction can be exercised. So what you are saying, actually I am not, that's not the query. Even I don't say that I cannot exercise. But you are saying all these conditions I have to read into your petition.
Right.
That's the difficulty.
Right. I have not argued still on merit of the case.
No, whatever the prayer, you see these conditions, that's a Whirlpool principle, that whether facts are not in dispute, I have to read into your petition.
Yes.
Then collection of money as cess without authority of law, that I have to read into. Then I have to read into that undue enrichment has not been made. Third thing. Fourth thing that I have to read again in your petition, that the amount was paid under protest. The writ petitions filed in the reasonable time.
No protest. Actually,
so Mr. De, so kindly just listen, since because I have to assist you again. The last 2 points you may say that I paid under protest and it is filed in the reasonable time.
I didn't pay them protest also.
Whatever they have debited it, so I have sent a protest letter.
No,
there is automatic debit from the account.
My
because this payment.
They are holder in good trust.
Yes. So
that is arbitrary.
How to read into the first three conditions? How to read the first three conditions?
That condition is laid down in paragraph 27. My humble submission.
Yes, you read it 27.
And it doesn't mention about cess or tax.
Yes.
It is in general.
Yes.
Therefore, the objection must also fail because in the given case, it is open to read court to give such monetary relief also. From the above discussion of ours, the following legal principle emerge as to the maintainability of a writ petition. A. In an appropriate case.
So how it is appropriate, Mr.
Unless I place my.
So please place that. Please place that in view of 25. This is appropriate. You show those three conditions.
No. Exactly. Unless I place the facts before your lordship.
So carry on, sir. Don't tell me that I will. You straight away come to those facts, those three conditions. The
My
first three conditions
right.
that were
Then I have to
facts
go
are
to-
not in dispute. Collection of money as cess was itself without authority of law. And the third thing was there is no undue enrichment. Because undue enrichment is a very crucial thing, Mafatlal. Sri Durga,
Right.
these line of cases.
Right, my lord.
Yes.
But
So when the Supreme Court says in an appropriate case,
Appropriate.
so this High Court has to say, or for the Supreme Court, that
Exactly.
Supreme Court has to say
exactly.
that this is appropriate case.
Appropriate.
And what is the requirement of appropriate case? Those three conditions are in 25. So
As in 27, my lord.
Sir, 27, so you are not reading. Again, problem, you are looking at me while
25 is extract of the
yes,
earlier
those principles, they have said that in an appropriate case, that's the in one word. So for to say that it's an appropriate case where High Court should interfere, those three conditions have to be satisfied. 3-4 conditions. Not exactly, it can be
exactly
put in a straitjacket that exactly those three conditions.
My lord, I have set up an industry where coal is a so we have got a linkage from Mohanadi Coalfield, which is a 100% subsidiary
You
of
are
Coal India.
chewing pan while speaking.
My lord,
You have put pan in your mouth.
sorry, my lord.
Pan ଖାଇଛନ୍ତି କି?
ନାଇଁ
ଆଚ୍ଛା ଆପଣ ଭଏସ କାଇଁ କ୍ଲିୟର ଆସୁନି?
ନାଇଁ ଚୋକ୍ ହେଇଯାଉଛି ଆଜ୍ଞା ଏଜ୍ ହେଇଗଲାଣି ଆଉ
ନାଇଁ ଆପଣଙ୍କ ଭଏସ କେମିତି ଚୋକ୍ ହବ? ତାହେଲେ ଆମେ କଣ କରିପାରିବୁ?
ମୋ ବୟସ 66 ହେଲାଣି ଆପଣ
ହେଲେ ବି ଠିକ ଅଛି ତାହେଲେ ଆମେ ବି ଏତେ ବି ୟଙ୍ଗ ନୁହଁ ଯେ ଆପଣ
ସେପାଇଁ ହୁଏତ ଚୋକ୍ ହେଉଛି କିଛି ଫିଜିକାଲ ପ୍ରୋବ୍ଲେମ
ନାଇଁ ସେଇଟା ତ that's unfortunate part God's grace you have recovered from that. କିନ୍ତୁ ଆପଣ ଯୋଉ କହିଲା ବେଳେ ଆପଣଙ୍କର ମାନେ ଉଚ୍ଚାରଣଟା ଗୋଟେ ଗୋଟେ ମିସ୍ ହଉଛି. Maybe yes,
maybe some difficulty, maybe. So, my lord, we entered into contract for supply of coal with Mohanadi Coalfield, other also Eastern Coalfield, and there is a contract for tenure of 5 years. Every contract. After 5 years, it lapses. Again, a new contract is entered into for supply. The contract I have annexed.
Annex
Annex 1.
Please kindly go to the disputes part. How the disputes, what is the contractual provision for settlement of
Exactly, that's I'm pointing out.
kindly go to that.
It is regarding
Which
the
page?
performance incentive.
Page.
Okay.
Which page?
Page 28.
28. Yes.
Clause 410.
28, page 28 you are saying. 28, 28.
28.
Yes. ପାନ ପକେଇ ଦେଇ ଆସନ୍ତୁ ଯଦି
ନା
ଅଛି।
ମାନେ
ଫୋପାଡ଼ି ଦିଅନ୍ତୁ।
ମୁଁ ପାଣି ଟିକେ ପିଇବି ବୋଲି ଭାବୁଛି ଗଳା ଶୁଭୁଛି 410 ମାଇଲ
ସେଠି ପାଣି ବାହାରେ ଅଛି ଯୋଉ ଆକ୍ୱାଗାର୍ଡରେ
ପଠେଇଛି ପେଜ 10 ସେଟା ହଉଛି କଣ performance incentive. If the MCL delivers me more than 90% of the allotted quantity in a financial year, then we have to pay them some incentive that has been provided here.
Yes.
410(3) is relevant. It happens annually, performed. Within 30 days of expiry of the year, the seller shall submit an invoice to the purchaser, with respect to the PI, that performance incentive payable in terms of clause 410(1). And the purchaser shall pay the amount so due within 30 days thereof of the receipt of the invoice. In the event of non-payment of PI by the due date, the seller shall have the right to suspend coal supplies without absolving the purchaser of its obligation under this agreement. Well, kindly.
Please.
My lord, this is the provision, and this contract relates to the tenure of 2008 to 2013.
Yes.
31st March 2013, the contract was concluded. Again, a new contract. whatever demand they have raised in invoice, we have paid it. Because in the MCL minors, they have to pay 100% advance money against a supply. Unless you are paying 100% cost, they will not supply. That is the procedure. So we keep some amount ready with them to their.
No, basically, what you are doing, you are trying to explain the contract and how the contract.
No,
is
I'm not. I'm just showing the relevant provision, my lords. So, my lords, year-end, they will send. Now, 2013 has been long elapsed after about 10 years. Suddenly, they issued an invoice. Kindly.
The provision where you have read that invoice is 4.10.3.
My lords. What you may be pardoned.
The invoice you are now trying to place before this court
Right.
emanates from 4.10.3.
Right.
It is that invoice.
It is that invoice.
Yes.
That was in invoice.
So you are to pay the PI to the seller, MCL.
They are demanding, but 2013 we have already paid every invoice raised for our supply. Now, my lords, kindly take page 64, Annexure 5.
Yes.
The date, my lords, see on the right hand side. The invoice was issued on 4 March 2023.
Yes.
10 years thereafter. This is for an amount of 25 lakh something.
Yes.
Then kindly take the last remarks column.
Yes.
What they say? Supplementary bill. On revision, that actually we have been supplied grade 8 coal instead of grade 9. So you have to pay the extra amount with GST. Minus GST regime came in 2017. This, even assuming a correct demand has been
Sir,
met.
you are reading GST where from? Where you are with GST, where you are reading?
Right.
I'm not getting it, sir.
My lords, I'm saying. My lords, see the heads, my lords.
Sir,
See,
you have to put it on your lectern, look there, read and find out where you are reading GST.
my
I
lords,
don't want that you say me like
head
this.
itself expresses
Screen ta share bulai diyo. Mu kon dekhuchi jani paru
state GST and central GST has been charged.
where you are reading that GST? You have to pay by GST.
Invoice letter, my lord.
Sir, read that line, sir. Don't do like this. I don't want that you
Total
do like
taxable value, basic value is 24 lakh somewhat. Central GST,
Yes.
IGST,
Yes.
12.
Sir, you are not reading. Again, the problem is that instead of reading, you are stopping there. Central GST is?
Central GST is 0.
Yes.
Then
State
IGST.
GST? State GST?
0.
0. Yes.
Then IGST.
Yes.
That amount is there.
Yes. So 5%, 24. So it can be for the entire period.
No.
If you are not again listening.
All right.
You have to be patient while interacting. So when you say including GST, so state GST according to is 0, central GST is 0. But anyway, that's besides those. So since you are reading it wrongly, so I pointed out. IGST is 5%. So what will be the 5% of 24 lakhs?
Well, I'm not. I just pointed out.
So you read remarks. So kindly read again remarks. Kindly again read remarks.
Right.
Yes.
Supplementary bill due to revision of basic price of coal from G9 to G8.
Yes. So you just point out that provision where it can be this supplementary bill can be raised in under which
There is
conditions?
no provision. That's my case, my lord.
So kindly show that. Kindly show that it is
So I have shown the provision for 10.3.
revision. I'm not saying
Revision provision is not there in contract, my lord. Again, there in contract, one thing, my lord.
Learned Counsel. So though I'm not admitting, I'm issuing notice on admission.
Uh,
So that should have been your first argument that day.
My lord, to limitation of my knowledge. My lord.
So you see the assisting counsel when is limited knowledge, the judge has no knowledge. That's the problem. If I would have been working for MCL or for the contractor, then I would have understood it within a few seconds. So you have to straight away come to the point that there is no provision for enhancement and they have enhanced it. So let them answer that, whatever. Otherwise, actually, I don't find that there is anything else. And Mr. CK De, Mr. DK De, CK De has become member, or you are there. The other day who has become member, tribunal member in this.
No, my lord.
He's not there.
We are two brothers.
No, I don't mean that he's related to you, not that sense. I just remember his name.
Actually, we are not related.
And I don't say that also. Mr. DK De for the petitioner. The Mr. Opposite Party blank. The learned counsel addressed arguments in extenso for admission of the matter. For the present, without admitting the matter, notice is issued on admission. As it is submitted that the bill dated 4/3, the invoice dated 4/3/2023 for the dispatch period 2012-2013 amounting to rupees 25, 90,430.40 is beyond the contractual provisions inasmuch as mentioned in the remarks column, supplementary bill due to revision of basic price of coal from grade 9 to grade 8 is not part of the contract, as there is no provision of any revision of basic price that is to be paid by the purchaser, MCL being the seller, nor there is any provision for raising any supplementary bill. Am I correct?
Right.
As in terms of the contract dated 28/4/2008, enclosed to the petition marked as Annexure 1. Let notice be issued by, let requisites for issuance of notice by registered post with AD be filed within 7 days. Within 7 days. When do you want?
Any day.
List after SR?
vacation.
List after SR? There is a miscase. Or it is, since it is already deducted.
Anytime after vacation.
Vacation परे कर दे. 10
जो लेते. I'm
Thanks for your assistance, because anyway, though perhaps those principles and may not be, but at least we discussed, there was a brushing up of the memory. But anyway, beyond Whirlpool, actually, perhaps the best is Whirlpool.
Well,
Those 7 principles, again, reiterated and here and there, and Whirlpool is not dealing with tax. Taxation is something different. Taxation, as such, High Court, Supreme Court, all have directed refund, including maybe after, only thing is that unjust enrichment as you are placing that matter. Yes.
of like
Item 6.
There is only one opposite party. Coal India. Can you take notice to both?
Both. I am taking
Notice to both. Yes.
Yes.
The opposite parties कर देंगे. Yes. Next.
Item 6.
May I please, Lordship? I have filed the miscase for recall of the order.
कोटा कहले miscase टा अछि.
Miscase 442
Flag A.
442 of
Yes.
2014 आगे.
Yes.
ସେଥିରେ ଅପିଲ ଏଗନେଷ୍ଟ ରେ କ୍ରିମିନାଲ ରିଭିଜନ ଆଜ୍ଞା ଏଟା ଠିକ ଅଛି ଏସଆର ପଏଣ୍ଟ ଆଉଟ କରିଛି ଯେ ସିଆରଏଲ ଏଲଏଲପି ହବ ସେ ଅନୁସାରେ ଅର୍ଡରଟା
Order recall हवा sir. 12/10/23.
ଆଉ ନୋଟିଂ ରେ ଆସିଛି 25 ନୋଟିଂ ରେ ଅଛି ସେ ଅର୍ଡରଟା ରିକଲ କରିବ ଅପିଲ ଏଗନେଷ୍ଟ ରିଭିଜନ ସେ ଏସଆର ପଏଣ୍ଟ ଆଉଟ କଲା ଯେ
वो order टा sir कोचुने आपण recall ପାଇଁ ଟିକେ
25 ଦିନ
पूर्ण order टा मो order टा देखि से डॉट की actually I'm sorry.
25 ଦିନ ତା ପୂର୍ବ ଅର୍ଡର
Usually कौन हुए कि the same bench रे आसे तो so I was stuck in my order I'm किछ बुझी कोन आपण recall चाहू
ପୂର୍ବ ଅର୍ଡର ଆଜ୍ଞା ପୂର୍ବ ଅର୍ଡରଟା ସେଟା ଗଡୁଛି
conversion टा आपण कोन भूल कोन हेची order टा sir.
ନା ଏସଆର ଆଜ୍ଞା ପଏଣ୍ଟ ଆଉଟ କଲା ଯେ ଅପିଲ ଏଗନେଷ୍ଟ ରେ ସିଆରଏଲ ଏଲପି ହବ
Leave petition हबो.
କିନ୍ତୁ ଏଟା
ହଁ।
ନୁହଁ ରିଭିଜନ ହବ ଅପିଲ ଏଗନେଷ୍ଟ ରିଭିଜନ
अच्छा.
ଜେଏମଏଫ ରେ ଏନଆଇ ଆକ୍ଟ ରେ ଫାଇଲ ହେଲା କନଭିକ୍ସନ ଅର୍ଡର ଏଗନେଷ୍ଟ ରେ ଆସିଲେ ସେସନ ଜଜ ରେ ଲରେନ୍ସ ଡିଷ୍ଟ୍ରିକ୍ଟ ସେସନ ଜଜ ରେ କଲେ ଅପିଲ ସେ ଅପିଲ ସେଟା ସାଇଡ ହେଲା ତା ଅର୍ଡର ଏଗନେଷ୍ଟ ଆମେ
एटा amendment परे
ଆଜ୍ଞା।
appeal lies to the sessions
Revision.
court.
ହଁ।
ता against आपण आसिले.
ଆସିଲେ ରିଭିଜନ ହବ ନା ସେଟା ଏସଆର ପଏଣ୍ଟ ଆଉଟ କଲେ ଆଜ୍ଞା ଯେ ସିଆରଏଲ ଏଲପି ହବ ସେଇ ଅନୁସାରେ ପେରିମିଟାରୀ ଅର୍ଡର କରିଦେଲେ କିନ୍ତୁ ଆମେ ଗୋଟେ ପୁଣି ମିସକେସ୍ କଲୁ ଯେ ନାଇଁ ଆମେ ଯୋଉଟା କରିଛୁ ଏଟା ଠିକ
4784 देखिले
442
478 सीआरपीसी रे 4 देखंतु प्रोविजन टा देखंतु से ओटा कहिचन जे तो फिर आपण देखियो ना विल नॉट इवन लुक एट दैट. का 478 भूल लिखा है. सेवेंटी ना कहते से चल पे 378. हाँ.
ଆଉ ଥରେ ସାର୍ ଅପିଲ କଲେ ଏଟା
378 ରେ आपण
second of
मजिस्ट्रेट कोर्ट अगेंस्ट रे 2A रे गले कोर्ट ऑफ सेशन को गले
ଆଜ୍ଞା
को प्रोविजन रे
ପ୍ରୋଭିଜନ କଲୁ ଆଜ୍ଞା ଦଉଛି सेवेन डेट रे हम ଯାଇଥିବୁ ଅପିଲଟା
सुबुनी है कोन कहउछनी सुबुनी जस्ट आप टिके लाउडर कोहंतु नले माइक्रोफोन को
378 रे
कोन अपील फाइल करचंदी से ऑर्डर टा
नहीं
अछि
सी करथिले आज्ञा ऑर्डर टा इधर अछि रेकॉर्ड रे अछि काइंडली सी एनेक्सर 2 मेन कॉपी रो
378
करी एठिक आसिलु रिवीजन आज्ञा आउ अपील होबनी अपील तो सेकंड अपील हिजो हमर क्षेत्र में मेंशन करि आज्ञा से मु पारा से मिसकेस रो पारा 7 रे मु लिखि छी पारा 7 रे लिखि छी
पढा देखिले टिके पढिले 4 टा
आज्ञा
378 4 टा टिके पढिले न बही नाही की
ओइटा
सेटा हिची कथा सेटा तो कहिबे बही नाही तो दैट आपण गोटे कहउचंदी मु गोटे बही धरि की पढुची दियंतु आ सीआरपी दियंतु सर दियंतु कोन सबथुर दीदी रा बही आनले आगे
This event appeal in case of acquittal, save authorized provide in section 2 subject provision of subsection 3 and 5.
सर एडिट आल समस्त पे पढतु टिके बेल कर दियंतु आपण निजे निजे पढलारो
378 appeal in case of acquittal. save as otherwise provided in subsection 2 and is subject to the provision of subsection 3 and 5. A, the district magistrate may in any case direct
କୋଉଟା ପଢୁଛନ୍ତି ନା କୋଉଟା ପଢୁଛନ୍ତି
378
378(4) ଆପଣ ସିଏ ଚ୍ୟାଲେଞ୍ଜ କଲେ
ଆଜ୍ଞା
ଇନିशिয়াল ଅର୍ଡର ୱାଜ କନଭିକ୍ସନ ନା ନାଇଁ
ଆଜ୍ଞା conviction
କରେକ୍ଟ ମୁଁ ଠିକ ବୁଝିଛି ତ ଦେନ୍ ହି ଚ୍ୟାଲେଞ୍ଜେସ୍ ବିଫୋର ଦ ସେସନ୍ସ କୋର୍ଟ
session
କୋଉ ପ୍ରୋଭିଜନ ରେ ଚ୍ୟାଲେଞ୍ଜ ଟା କୋଉ ପ୍ରୋଭିଜନ ରେ ହେଲା ସାର୍
378 appeal in case of acquittal
ହଁ
ସେଠି conviction ହେଲା ସେ 378 ରେ ଚ୍ୟାଲେଞ୍ଜ କଲେ
କଲେ
acquittal
କଲେ
provision ରେ
ସେଥିରେ ଆକ୍ୟୁଟାଲ ହେଲା
ଆଜ୍ଞା ନାଇଁ ନାଇଁ ସେଥିରେ conviction ହେଲା କୋଉଠି ଏନ୍ଆଇ ଆକ୍ଟ
ଆପଣ
ରେ
ସେ କହିଲା ବେଳକୁ କିନ୍ତୁ ଅସୁବିଧା ହଉଛି ତାହେଲେ ଆପଣ ଯଦି
ଲରେନ୍ ଜେମେକ୍ସ
ଆପଣ ଏଥିରେ କମ୍ପ୍ଲେଣ୍ଟ ନା ଅପୋଜିଟ ପାର୍ଟି ଥିଲେ ପ୍ରଥମ କେସ ରେ
ପ୍ରଥମ କେସରେ ଆଜ୍ଞା ଆମେ
ପ୍ରଥମ କେସ ଟା ଆକ୍ୟୁଟେଡ ହେଲା ନା କନଭିକ୍ସନ ହେଲା ଆପଣ ମୁଁ କନଭିକ୍ସନ ପଚାରିଲି ଆପଣ 3 ଥର କହିଲେଣି ହଁ ବୋଲି ଫାର୍ଷ୍ଟ ଷ୍ଟେଜ ଅଫ ଇନିशिয়াল ଷ୍ଟେଜ ଅଫ ଯୋଉଟା ହେଲା କୋର୍ଟ ଅଫ ଫାର୍ଷ୍ଟ ଇନଷ୍ଟାନ୍ସ ରେ
ସେଥିରେ ଆମେ କମ୍ପ୍ଲେନାଣ୍ଟ ଥିଲୁ ଫାଷ୍ଟ ଇନିशिଆଲି
କମ୍ପ୍ଲେନେଣ୍ଟ ଥିଲେ
ହଁ।
ଆପଣ ହାରିଲେ ନା ଜିତିଲେ
ଆମେ ଜିତିଲୁ
ସେ କନଭିକ୍ଟେଡ ହେଲେ
କନଭିକ୍ଟେଡ ହେଲେ ତା
ଆପଣ
ଅର୍ଡର
କେମିତି କହୁଛନ୍ତି ଆକ୍ୟୁଟାଲ ହେଲା ବୋଲି ସୋ ଯଦି କନଭିକ୍ଟେଡ ହେଲେ କନଭିକ୍ସନ କୁ ଅପୋଜିଟ ପାର୍ଟି ଚ୍ୟାଲେଞ୍ଜ କଲେ
ଚ୍ୟାଲେଞ୍ଜ କଲେ ସେଠି ସେଟା ସାଇଡ ହେଲା
ଆକ୍ୟୁଟାଲ ହେଇଗଲା
ଆଜ୍ଞା
ସୋ ଇଟ୍ସ ଅର୍ଡର ଅଫ ଆକ୍ୟୁଟାଲ
ତା ଅର୍ଡର
ସୋ ହି ତ ଆପଣ ଚ୍ୟାଲେଞ୍ଜ କରୁଛନ୍ତି ଅର୍ଡର ଅଫ ଆକ୍ୟୁଟାଲ
ଆଜ୍ଞା
ପଢନ୍ତୁ 378(4) ଆପଣ କଣ ବହି ଦେଇଛନ୍ତି ସେ ପୃଷ୍ଠା ପାଉନାହାନ୍ତି କୋଉଠୁ ବହି ଆଣିଥିଲେ କଣ ସାର୍ ଆପଣ ଗୋଟେ ଏମିତି ତ ବହି ଦେଇ ଦଉଛନ୍ତି ସେ କିଛି ପାଉନାହାନ୍ତି ଆପଣ ଗୋଟେ ୟୁ ଆର ଆଡିଂ ଫର୍ଦର
ଫୋରଟା କାଇଁ କ୍ଲଜ 4
ନାଇଁ ପଡେ ସେ ସେମିତି ସେ ବହିଟା ମତେ ଦିଅନ୍ତୁ ଆପଣ ଏଇ ବହିଟା ଦିଅନ୍ତୁ
କ୍ଲଜ 4 ଟା ପାଇଲେ
ଅଛି
ହଁ।
ନାଇଁ ଆଇ ଏମ୍ ସରି ମିଷ୍ଟର ପ୍ରରାଜ
ନାଇଁ ନାଇଁ ପାଇଲେ 4 ଟାରେ ଆଜ୍ଞା if such a order of acquittal in past any case instituted upon a complainant and the high court
ନାଇଁ ମୋ ସାର୍ ଏମିତି
on
କଣ
an
କମ୍ପ୍ଲେନେଣ୍ଟ ତ
application
ନାହିଁ
ଆଜ୍ଞା
ଏଟା କୋଉ ସିଆରପିସି କି 1973 ତ ଇନଷ୍ଟେଡ ଅପନ କମ୍ପ୍ଲେଣ୍ଟ କମ୍ପ୍ଲେନାଣ୍ଟ କୋଉଠି ଅଛି
ଲେଖା ହେଇଛି କମ୍ପ୍ଲେନାଣ୍ଟ ଲେଖା ହେଇଛି ଆଜ୍ଞା
କମ୍ପ୍ଲେନାଣ୍ଟ ଲେଖା ହେଲା
ହଁ କମ୍ପ୍ଲେନାଣ୍ଟ ଲେଖା ହେଇଛି ଯାହା କ୍ଲଜ 4 ରେ ଲେଖା ହେଇଛି if such an order of acquittal is passed in any case instituted
ସ୍ପେଲିଂ କହିବେ
upon
ଟିକେ
complainant and the high court
ସାର୍ ଟିକେ ସ୍ପେଲିଂ କହିବେ କମ୍ପ୍ଲେନାଣ୍ଟ ର
COMPLAINANT complainant
ନାଇଁ ତାହେଲେ କଣ ପ୍ରୋବ୍ଲେମ ଅଛି ବହିଟା ଦିଅନ୍ତୁ
Clause 4
ଠିକ ଅଛି ସାର୍ ଦେଖନ୍ତୁ ଆଉ ଥରେ ସ୍ପେଲିଂ ଟା ଦେଖନ୍ତୁ ନାଇଁ ସେ ସାର୍ଙ୍କ ବହି ଠିକ ଅଛି ଆପଣଙ୍କ ଛୋଟ ଛୋଟ ଅକ୍ଷର ବେଶୀ କନଫ୍ୟୁଜନ ହବ ଆପଣ ସବୁଠୁ ଛୋଟିଆ ପ୍ରିଣ୍ଟ ବାଲା ଆଣିଛନ୍ତି ମିଷ୍ଟର ଏଚପି ଦାସ ଆମ ପାଇଁ ନୁହଁ ସେ ବହି ଏମିତିରେ ତ ଚଷମା ଲାଗିଛି ଛୋଟ ଛୋଟ ଅକ୍ଷର ଆପଣ ଆଣିକି ଦଉଛନ୍ତି
ମୋର ବି
COMPL ତାପରେ କଣ ଅଛି
COMPLAINANT
ଆଜ୍ଞା କୋଉଠି ଅଛି ମୁଁ INN କୋଉଠି କରୁଛନ୍ତି କମ୍ପ୍ଲେଣ୍ଟ
complaint
ନାଁଟା ଆଜ୍ଞା ନୁହଁ ସେଟା
ଯାହା ଆଜ୍ଞା ଲେଖା ହେଇଛି
କମ୍ପ୍ଲେଣ୍ଟ ସାର୍ କମ୍ପ୍ଲେଣ୍ଟ ଆଉ କମ୍ପ୍ଲେନାଣ୍ଟ ଆର୍ ଡିଫରେଣ୍ଟ
ତ ଲେଖା ହେଇଛି COMPLAINANT ଯାହା ଲେଖା ହେଇଛି
କୋଉଠି ପଢୁଛନ୍ତି ଆପଣ
କ୍ଲଜ 4 ପଢୁଛି
ମୁଁ 3 ଥର ପଢିଲିଣି
ଯାହା ଆଜ୍ଞା ଲେଖା ହେଇଛି ବହିରେ ମୁଁ କହୁଛି
ନାଇଁ ସାର୍ ଘରେ ଲେଖା ହେଇନି ସାର୍ ମୁଁ କେମିତି
ଏଇଟା କଣ କମ୍ପ୍ଲେନାଣ୍ଟ
ଆପଣ ଛୋଟ ବହିରେ କଣ ଲେଖା ହେଇଛି
କମ୍ପ୍ଲେନ୍ ଆଣ୍ଡ କମ୍ପ୍ଲେନାଣ୍ଟ ଆଜ୍ଞା ଅଛି ଏଇଟା ଫାଷ୍ଟ ଅଛି କମ୍ପ୍ଲେନ୍
ରହିଯାନ୍ତୁ ସେଟା ଆପଣ ଫାଷ୍ଟ ହିଁ ଅଛନ୍ତି ଥ୍ୟାଙ୍କ ଗଡ ଆପଣ ଆଜି ଡିକେ ଦେଙ୍କ ମ୍ୟାଟରରେ ଥିଲେ ଆପଣ ବସି ଠିକ ଅଛି କମ୍ପ୍ଲେଣ୍ଟ କମ୍ପ୍ଲେନ ନା କମ୍ପ୍ଲେନାଣ୍ଟ
ନା ଫାଷ୍ଟ ରେ ଅଛି କମ୍ପ୍ଲେନ୍
ସେଇଠି ଆପଣ ଫାଷ୍ଟ ହିଁ ଅଛନ୍ତି ଫାଷ୍ଟ ହିଁ ଆପଣ ଅଛନ୍ତି ଆପଣ ତା ଆଗକୁ ଯାଇନାହାନ୍ତି ଆମେ ସେଇଠି ଅଟକିଛେ ବର୍ତ୍ତମାନ
ଆଜ୍ଞା
complaint instituted upon complaint
ଆଜ୍ଞା
yes
complaint and the high court
comma then
on an application made to be it by the complainant
and to be ଅଛି
to it by the complainant
ସେଇଟା କମ୍ପ୍ଲେନେଣ୍ଟ ଆପଣ
ହଁ।
ଯୋଉ ତଳ ଉପରେ
No, no,
ହେଇଯାଇଛି
in this we have grant special leave to appeal from the order of acquittal. The complainant may present such an appeal to the High Court.
ଆର କଣ ଇଣ୍ଟରପ୍ରିଟେସନ ଆପଣ ଯୋଉଟା କହୁଛନ୍ତି
ଆଜ୍ଞା
what you are saying is contrary to this. You are the complainant who has presented a complaint.
complaint.
Complaint ରେ टी ଟା ସାଇଲେଣ୍ଟ ରହିଲେ ବି ହବ complaint ବା complaint.
ଆଜ୍ଞା
So in such of if such an no appeal to High Court 5 ବି ଦେଖନ୍ତୁ 3 ଦେଖନ୍ତୁ ସରି 5 କହୁଛି 3 ମୋର ବି କନଫ୍ୟୁଜନ ଆରମ୍ଭ ହେଇଗଲା 3 ଟା ଜଷ୍ଟ ଦେଖ ବହିଟା ବନ୍ଦ କରନ୍ତୁନି
କୋଉଠି ହେଲା? ପାଞ୍ଚଟା ଆଜ୍ଞା କ୍ଲଜ 5
3 ଦେଖନ୍ତୁ ଆଉ B ଟା ବି ପଢନ୍ତୁ
ତିନିଟାରେ ଆଜ୍ଞା
ତାହେଲେ ହଁ 3 ରେ କଣ ଅଛି
ତିନିରେ ଆଜ୍ଞା ଅଛି no appeal to the High Court under subsection clause 1 or a subsection 2
Hmm.
shall be entertained except with the leave of the High Court.
So ଆପଣ କେମିତି ୱିଦାଉଟ୍ ଲିଭ୍ କେମିତି ହବ ତାହେଲେ ଆଜ୍ଞା ଯିଏ ଅର୍ଡର ଟା ବି ଯିଏ କରିଛନ୍ତି ହି ଇଜ वन ऑफ द बेस्ट जजेस ओडिशा हैज प्रोड्यूस्ड इज डायरेक्ट डिस्ट्रिक्ट जज ଆପଣ କେମିତି କହୁଛନ୍ତି ଏଟା ୱିଦାଉଟ୍ ଲିଭ୍ ହେଇଯିବ ବୋଲେ ସିଧା ରିଭିଜନ ହେଇଯିବ ନାଉ ୟୁ କ୍ୟାନ୍ କାଇଣ୍ଡଲି ରିଡ୍ 375
ଆଜ୍ଞା
ମୂଳରୁ ପଢି ପାରିବେ ସରି 378 ଜଷ୍ଟ ଫାର୍ଷ୍ଟ ଟା ପଢନ୍ତୁ 378 1 ଟା ପଢନ୍ତୁ
save as otherwise provided in subsection 2 and subject to the provision of subsection 3 and 5.
So it has appealed in case of acquittal shall be filed so save as otherwise provided in subsection 2 and subject to provisions of 3 and 5 ଆପଣ ବର୍ତ୍ତମାନ 3 ପଢିଲେ
ଆଜ୍ଞା
without leave କେମିତି ଆପଣ acquittal against ଆସିବେ now you are saying ମାନେ ଲିଭ୍ ଦରକାର ନାହିଁ ବୋଲି କାହିଁ କହୁଛନ୍ତି ସାର୍ ଆପଣ କାହିଁ କହୁଛନ୍ତି ଲିଭ୍ ଦରକାର ନାହିଁ ବୋଲି କୋଉ ପ୍ରୋଭିଜନ ରେ ସେଟା ହବ ଆପଣ ଲେଖିଲେ 3401 397
ଆଜ୍ଞା provision.
फोर जीरो वन केमती हम एटा पढ़ुना 401 401 doesn't exclude sir 378 378 is not excluded 401 देखुना जो माने स्टाम्प रिपोर्टर थांती लाइक इवन एबे भी थिबे ओल्डर से माने दे चेक द प्रोविजन then they place for consideration before the judge after it has been considered by the stamp reporter and judge the order has been passed आपण किंता रिकॉल फाइल कर दोचंती रिकॉल हेले आपण तो कन्वर्सन करिवेनी आ केमते हबो एग्जामिन करंतु
examine I will examine
आगे आगे
I will examine
आपण जोटा रिकॉल फाइल करिसेंती से ऑर्डर टा फॉर when अच्छा the other problem you are the counsel who appeared originally or now you are appearing
no no on behalf of Mr. Das Vikram
then he must be see appear करथिले ऑर्डर हेला बेले तो फर्स्ट ऑर्डर जेतेबेले हेला तो कन्वर्सन
no 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 नयागड केस
एटा डिसमिसल ऑर्डर हे जाइछ
नयागड केसटा से ना सेठी न करना
4714 रे हेला ऑर्डर if since it has not been converted within 7 days the matter shall stand dismissed 25/3/14 रे आपण लीव नेले कोर्ट रु टू फाइल एस एलपी कोर्ट रे प्रेयर करिकि नेले 25/3/14
ଆଜ୍ଞା
तापर आसला 4/7/14 सेम बेंच आपण वर्तमान माने आफ्टर मोर देन 9 इयर्स आपण आछंती ताको रिकॉल करिया पय फेरे
ରହିଯାଇଛି ତ ଲିଷ୍ଟ ହେଇନି ଆଜ୍ଞା
मिस्टर दास को पचारिबे ताले
ଆଜ୍ଞା
जी एटा करिसेन ताको नले पचारंतु
ଆଜ୍ଞା
ही मस्ट हैव से ए आईडिया टा किए तला रिकॉल फाइल करिया पय 2014 ऑर्डर टा
सिनियर दास
से निजे कहले
ଆଜ୍ଞା
very strange. Then he was present on both the occasions and the order was passed in his presence. On 25/3/14, steps for conversion, 2014, steps for conversion shall be taken within 10 days. Then it was again not done. It has placed before the bench. Then the bench directs steps for conversion shall be taken within 7 days. Failing the criminal division shall stand dismissed without further reference to the bench.
next week I will examine.
Jete samay nebe niyontu, but be
next week
be sure about what you are submitting. Your submission is not I mean in sync with the provision. You are Mr. Misra. Mr. S.K. Misra for the petitioner. Miss Case 442 of 2014. By 25/3/2014, the hard learned counsel for the petitioner. Eta miss case ta likhile. By order dated 25/3/14, the following was directed. Court kardele. Thereafter, when the CRL LP was not filed, again on 4/7/2014, the following order was passed. The order dated 25/3/2014 is pursuant to the stamp report dated 21/1/2013 to the following effect. Quote kar diyantu. Nomenclature is not correct. CRL LP is the correct nomenclature under section 478 into bracket 4 CR.P.C. The miscase for recalling the order, the miscase ta 14 file करछन्ती.
ଆଜ୍ଞା 3/4/14
अच्छा, that date I did not mark. 3/4/14 रे पास हेले तला आपण केमती 4/7 ने केमती ऑर्डर हे गला. The miscase for recalling the order dated 25/3/14 was filed on 3/4/14. मु न देखि कर दोची फेर कोन भूल भालो. Filed on केते देखा जाउछ आज्ञा. हां 3/4/14 on 3rd April 2014, which is which has been which was placed for consideration today. On prima facie reading of the provisions contained in the CRPC, this court is of the considered in opinion of this court. The stamp report is correct in as much as the present petition challenges a order of acquittal passed in appeal by judgment dated 2/2/2011 in criminal appeal number 8/4 of 2010/2007 against the order of conviction passed by the court of JMFC Noyagada. Order of conviction dated kar diyantu. Date ko date ta gote padeni. JMFC Noyagada in 1CC 1.C.C case number 171 of 2005. Therefore, the prayer made in the present miscase is not tenable. Para. The learned counsel for the petitioner seeks further accommodation. to examine the matter and advance arguments as prayed for. List केबे चाहूछन sir?
next week.
December रे कर देबे?
Next week. Only 7 days.
19 ना ता पूर्वरु ना परे
आगे?
जनवरी केबे चाहूछन सर आपण लिस्टिंग
December.
ठीक अछि ताले एक 15-12 कर दियन
आगे.
yes
7,
7, my lords, the address verification.
sir Praharaj, you are saying that it is against acquittal, so there has to be LP.
yes, leave to.
I heard that, but I think Mr. kindly examine
Aye.
because then it will be setting a wrong precedence.
Aye.
Contrary to High Court rule, contrary to CRPC. ଆପଣ ଯୋଉଟା direction ହେଇଛି peremptory order that it shall be dismissed with the reference to the bench ସେଟାକୁ ବି recall file କରିବା କଥା ନୁହଁ ଯଦି ଏଟା file କଲେ. Now how I will modify that order? ठीक अछि ମାନେ for a arguable case ଆପଣ କହି ପାରନ୍ତି ଯେ ସେ order ଟା peremptory ଥିଲା ଆପଣ 9 ବର୍ଷ ପରେ I will modify that order and that also please consider. कि नोटे लीव टू द फाइल करिवे कि पिटिशन प्रेयर तो करिवे जे दैट ड्यू टू इनएडवर्टेंस मो फाइल करि पानी व्हेनेवर आई एम ग्रांटिंग दैट आई एम रिकॉर्डिंग दैट इट इज सबमिटेड दैट ड्यू टू इनएडवर्टेंस एटा करि हेलानी सो दिस 6 फॉर द टाइम किछ तो लिखिवे बिना केमती होबो एटा दैट डजंट माने डजंट लुक गुड जो दिन जहा मन को आसला हम ऑर्डर कर देबो कोन ठीक कथा सेटा ये आसिनी रिपोर्ट
My lord, there's 2 addresses. His permanent address is verified in MP, but his current address is in Chhattisgarh. That report hasn't come.
This
So I have got a report from the Madhya Pradesh local IAC
okay
saying that his present address is correct, but it doesn't stay there.
okay
His current address in Chhattisgarh.
it is that case where you earlier also pointed out that he's not staying at his place or maybe that's a case from Bihar.
Also 11/7 of 23 order dated. The IIC also verified the same and reported to the
No, Chhattisgarh there is a direction.
No, my lord.
11-10.
Confirm 11/7, my lord.
11-10 order.
1110.
There is an order
11/7
directing him to obtain instruction.
The earlier 11/7/23, my lord.
ମୁଁ ଯାଉଛି sir ଆପଣ ବୁଝି ପାରୁନାହାନ୍ତି ମୁଁ କଣ କହୁଛି ଆପଣ ଗୋଟେ 11-7 ଥରେ କହିଲା ମାନେ ଚାଲିଲା ସେଟା
No, no.
ଆପଣଙ୍କ କଥାଟା ମୁଁ ବୁଝିକି ତାପରେ ତାଙ୍କ କଥା ବୁଝିକି ଗୋଟେ ତ ରେସ୍ପଣ୍ଡ କରିବି
Yes, sir.
ସିଏ କହିଲେ ଯେ ବର୍ତ୍ତମାନ ସେ ଛତିଶଗଡ଼ରେ ରହୁଛନ୍ତି ଆମେ ବୁଝୁଛୁ so to that I am answering yes there is an order 11-7 so he has not come here ଆପଣ ଯୋଉଟା କହୁଛନ୍ତି ସେଟା ଆଉ ଗୋଟେ order କେବେ କହୁଛନ୍ତି ସେଟା
11/7/23.
11 my order is something different 11-10 I was referring to that order. Yes, how does it help you? 11-7 रे कौन ହେଇଥିଲା?
The concern IIC. Ajio Sudarshan Bag, my lord. Baripada Town PS.
Yes.
Appeared through the virtual court, my virtual.
Mr. Counsel, actually he is saying that only.
Yes, ma'am.
He is saying ଆପଣ 3 ଲାଇନ୍ ତଳେ ପଢିଲେ ବୁଝି ପାରିବେ.
We also inform that the said instruction in writing is expected to be received by him within a day or two.
ତା ପୂର୍ବଟା ଛାଡୁଛନ୍ତି ତ ଠିକ most vital part ଆପଣ ଛାଡି
He
ଦଉଛନ୍ତି.
submits that he has received oral instruction from
Yes.
his counterpart of Kotma police station, Islamganj, in the district of
Anupu.
in the state of Madhya Pradesh regarding address verification of the petitioner who
Then
hails from
comma.
Chhattisgarh.
Who hails from Chhattisgarh.
He also
So
informed
that exactly he is saying what you are saying. He is saying that he is from Madhya Pradesh. Police has confirmed his address, but Chhattisgarh, because of 11-7 order, I have only directed on 11-10. That what happened to this verification from Chhattisgarh. Ne apun ଆଉ କଣ କହୁଛନ୍ତି?
No, my lord.
So
After that,
so all three of us are saying the same thing. So then what next? ସିଏ ଯାହା କହୁଛନ୍ତି ଆପଣ ସେୟା କହୁଛନ୍ତି ମୁଁ ବି ସେୟା ବୁଝିଛି. 11-7 the coordinate bench this the local Baripada police appeared and he said that from this Nawabganj that he has whatever Kotma police station, I'm sorry, Islamganj, that he has verified that he is, but he's from Chhattisgarh. Then kindly just the next order, that is how to obtain instruction from the state of Chhattisgarh of the local area of residence through the concerned SP regarding the allegations of criminal incidents against the petitioner. That is still pending, that is praying time. You are Mr. Raut.
KC Behra.
Mr. KC Behra. KC Behra for the petitioner, Mr. Devasis Naik AGA for the state. The learned counsel for the state seeks further accommodation to obtain instructions in terms of the earlier orders dated 11/10/2023, reiterated on 7/11/2023. And this has happened only because he said, the IAC said that he's from now he's from Chhattisgarh, from Madhya Pradesh. His local area has been local residence has been verified.
Also, the first title mallet at present address is Chhattisgarh.
Yes, absolutely. How much time, Mr. Naik?
2 weeks.
2 days. 22 तारीख. List on 6. That week, 6th, 8th. Oh, when do you want?
No, yes, yes.
On 8th of December.
Please. 8th mallet. 8th.
8th. You have difficulty?
Yes, sir.
Go. The next week.
13.
13, 14. I think it's 14.
Oh, bless.
Item 8.
May I please, Lord, sir? May I, on behalf of Devasnanda Sahib, pray for an adjournment.
You are Mr. Sorry.
S. Satpathy.
You have
No, my lord.
Mr. S. Satpathy.
My
Mr.
lord.
S. Satpathy on behalf of Devasnanda Das for the petitioner.
Okay.
Mr. Devasis Naik AGA for the state. Learned counsel for the petitioner seeks accommodation to advance argument. As prayed for list on 6th of December 2023 to grant further opportunity to the petitioner.
Oh, bless.
The learned AGA submits that case diary is available along with statement of the victim recorded under 164 CRPC.
Item 9.
Yes. Yes.
Item, my lord, or 2 weeks time to file the comprehensive.
You are Mr. HP Das. Mr. Your name, sir?
Adhikari Chittaranjan Das.
Mr. A.C.R. Das. Mr. A.C.R. Das on behalf of the petitioner. Mr. Devasis Naik AGA for the state. The learned counsel for the petitioner seeks accommodation to advance arguments. Further accommodation. As prayed for list on. You have complied the order regarding filing of affidavit.
Comprehensive
The affidavit on behalf of the petitioner shall be filed by the next date. Copy be served on the learned AGA to obtain instructions. How much time you require? The entire time to file the affidavit? Fair enough.
Item 10 also same.
Same affidavit not filed.
No, not filed.
Same order. Affidavit to be filed.
No, bless.
9, 10 କହିଦେଲେ
7/12.
7/12. Yes.
Item 11.
ଡାକିବାକୁ ସମୟ ହବ ଆଉ to be.
On behalf of Mr. Sahoo,
Yes.
next week, Miller.
Or it will be called, no, it will be passed over or it will be adjourned. What do you
Adjourned,
want?
Miller.
Mr. Jena on behalf of Mr. Jagabandhu Sahu for the Suresh Chandra Jena. Mr. S.C. Jena on behalf of Jagabandhu Sahu for the petitioner. Mr. Devasis Naik AGA for the state. The learned counsel for the prayer for adjournment is made on behalf of the learned counsel for the petitioner as prayed for list on 11 December to grant further opportunity. The medical examination report you have
there.
received.
along
There.
with the case diary.
The learned AGA submits that he has received the case diary, including the statement of the victim recorded under the section 164 CRPC. Yes.
Item 12,
May I please, your lordship, my lord, 3 weeks time may kindly be given.
Your name, sir?
D. Mahapatra, my lord.
Mr. D. Your power here.
Yes, yes, my lord.
Mr. D. Mahapatra for the petitioner. Mr. Devasis Naik AGA for the state. The learned counsel for the petitioner seeks accommodation. Further accommodation to comply with the order dated. You have filed affidavit.
No, no, my lord.
Comply with the order dated 31/10/2023. To file कौन लिख ले? For filing affidavit on behalf of the petitioner indicating the past allegations of criminal activity, comma, if any. How much time you require to file the affidavit?
My lord, 19, my lord.
By 19 you will file the affidavit.
No, no, my lord. I will file 13th.
As prayed for the affidavit we filed within by 13th.
Yes,
There
ma'am.
by 13th December 2023. Copy be served on the learned AG to obtain instructions. You have case diary.
I have the case diary.
The list on कर दियो तापर लिखिए list on
बार
13th पर से 13th रे दोचन का affidavit 18 कर देबे list on 18
Bless me.
1812, my lord.
18/12/2023. The learned AGA submits that the case diary is available.
Ma'am.
Yes.
Bless me.
13,
So Hota,
Item 13 prefer 2 weeks.
Mr. S. Hota for on behalf of SK Divedi for the petitioner. He's writing SK or S. Divedi? Mr. S. Divedi for the petitioner. Mr. Devasis Naik AGA for the state. The learned counsel for the petitioner seeks accommodation, further accommodation to advance arguments. As prayed for list on
14 बार
14th December 2023, the
Well,
learned AGA
items-
submits that. Sorry.
Item 16, the two cases arise out of the same FIR. They're co-accused.
Okay. There 13/16.
My lord.
Okay. That case diary is available.
Item 16 also prefer 2 weeks.
Same 16 the first item देखो So S Hota is there.
Both
So,
items.
S Hota for the petitioner. Then the sub item 16 S Hota on behalf of Amitabh Tripathi. So you are there. Sorry. Sub item Mr. Amitabh Tripathi. Appearance change here. In all the cases you are there, Mr.
Ma'am.
Naik. Devasis Naik. Yes.
14,
Yes.
In this case, my lord, earlier the father of the petitioner filed an affidavit that he along with others went to the house of the victim.
Umasankar, just a second. Let me note the appearance. Umasankar Patel for the petitioner. Mr. Devasis Naik AGA for the state. MS. Likhiwe. Mrs. Suprabha Patel. Mrs. Patel, you are there.
Yes, sir.
Mr. MS. Suprabha Patel for the informant. So after filing of the affidavit, Mrs. Patel, is there an instruction from the that what they say, what the informant, what they say?
Sir, the parents of the accused had gone to the house of the victim, sir, but they offer money for compromise, sir. They are not interested for compromise, sir.
Is there any threat perception? Compromise obviously not permissible also. Is there any threat perception? What is the age of this accused, Mr. Patel?
25.
25 or 28? कौन कहले आउतरे 28 ना 25?
But we has
But
FIR is
You
FIR
see-
has gone to consume liquor. You Lordship, I'll say paragraph 5 of the PWR statement.
cross-examination.
Cross examination.
Yes.
My deceased brother was consuming liquor, my lord.
Yes.
And the wife also says same thing and mother says same thing.
Sir, do you mean to say that a person who is alcoholic has a less, he has inferior right to life or what?
No, my lord. Your
So,
Lordship kindly see.
The deceased being killed or so how is it relevant that whether he was consuming, he was an alcoholic or not an alcoholic or
And your Lordship kindly see, she says he had, but nobody said from whom it has been had. And your Lordship kindly say PW3. Your Lordship kindly
please
PW3.
check in cross-examination. In fact, rightly he has not been asked that question.
PW3, your Lordship kindly see.
Because once he has stated that, because this whoever is conducting the trial, I don't know, maybe you, but
Yes.
that you see, the whole story is that I mean the entire case is that the dead body is found. So anyone will hear that a dead body is falling somewhere.
But he heard that these accused persons are involved in that, my lord. That is the FIR story.
In killing of his brother,
FIR story.
because once he says, I have seen these persons killing my brother, he is an eyewitness.
Yes.
But here that is not the case. The
But he
case is
had.
that he went with some people.
Who had, but
So
from whom had it is not
only,
disclosed.
only if para 5 what you are saying,
Yes.
if you say that he was forced to take liquor, then it has some relevance. But that's not the case.
But FIR,
Then PW3,
well, PW3, my lord, if your Lordship will go to paragraph 4, cross examination, my lord.
PW3,
He said, my lord, PW3 is the mother of the deceased. Paragraph 3, my lord. I
para
have
2,
heard
then,
the accused
then
person.
she says the same thing.
My lordship,
Accused
Due
persons
to-
and the deceased had
due
gone to village Hon'Ble for feast. In the late night, all the accused persons returned, but my son had not returned to the village, for which asked him. The same things he's saying.
PW3, your Lordship reading.
Yes.
I have heard the accused, paragraph 3, my lord. I have heard the accused persons have committed the murder of my son, my lord.
Yes.
But from whom I heard, your Lordship, paragraph 4. Paragraph 4, cross
Yes.
examination. He said, due to disclosure of the accused persons, I knew that. Paragraph 4. I don't
that-
remember the exact date.
That has no bearing, sir. So now this question will answer, everyone will answer that. That we have heard that they have killed.
And there,
So there is a possibility they will not be able to prove the case. But as far as the bail is concerned, I think all have implicated, as far as last seen theory is concerned, both 1 and 3 have implicated these persons. And you wait for some time.
There is a clear discovery lead, 27 statement is there leading to discovery
Leading to
of those
discovery.
artifacts.
lead to
That is
disclosure
clear.
of
Leading to
speak and
discovery,
stone.
no, Mr. Das, leading to discovery, has the person being examined regarding leading to discovery?
Yes, my lord. Yes,
Any witness?
that did not support. That did not support.
Kiye se?
PW,
Nada kuhନ୍ତୁ.
my lord. PW7.
Jodi examine hei nahanti,
No, exam PW7.
jodi hei nahanti, tale wait, then it will be, then
PW7, your Lordship.
7 other 9. 7 9 mopa.
PW7.
I also don't have 7. Mobile nahi.
6 କହୁନାହାନ୍ତି ତ?
ନାଇଁ 7 କହୁଛି ଆଉ ଗୋଟେ ଅଛି
ତାହେଲେ ଆପଣ ଦିଅନ୍ତୁ
7 ରୁ ଆଉ 11 ପର୍ଯ୍ୟନ୍ତ ଅଛି ଦେଇନି
ସେଟା କହିବେ ନା ଆଉ। Mr. H.B. Das for the petitioner, Mr. Devashish Naik AGA for the state. The Learned Counsel for the petitioner advanced arguments and submits that he has copies of the deposition of the PW 7
to 11
7 to 11,
My lord.
which he shall file in the file before this court and
Court.
also serve copies on the learned AGA.
yes
Aji serve karibe within 2 days.
Today.
2 days. When do you want? Kebe chahunchhanti?
next week my lord 2 days after your
As per for list aji kete 22 tarikh.
Aଜ୍ଞା.
List on 30
30 ଜଣ
30 11
of list
ଆପଣ 30 ରେ ବହୁତ ମ୍ୟାଟର ଲିଷ୍ଟ କରିଥିବେ। ବେଲ ଗୁଡାକ ଆଡ୍ କରିବେ, ଅନ୍ୟ ଗୁଡାକ ପଛରେ କାଟିବେ। ୟେସ୍
18,
Item 18, Mayor, please, Your Lordship. in the previous date, my lord had asked me to file the bailer along with.
So you have served copy. They will verify. They
Yes,
can
sir.
verify.
Your lordship,
When did you serve? When did you serve?
your lordship, I served yesterday.
Yesterday only.
Yesterday only.
Okay. Now, Mr. Naik, suppose you think, I'm just thinking it aloud. If this court is persuaded to grant bail, the conditions are very important.
My lord.
And the most important, as both of you know, is a flight risk.
So the passport has to be seized.
Sir,
He will surrender. He will definitely surrender.
My lord had asked me for this instruction also. It is, I have confirmed that it is surrendered. Already it is
No,
surrendered.
there also has to be a standing lookout notice in all airports.
So please,
International airports.
now you have understood the point.
My lord.
Thanks for that. Immediately you have responded. So you please, put it on a piece of memo or whatever.
My lord.
You consult the investigating agency,
My lord.
passport surrender, standing lookout notice,
My lord.
and all these, whatever conditions, how they are handling the foreign nationals.
My lord.
My
My
lord.
lord.
You also please examine that.
Custody is more than 1 year, my lord, now.
It has to be, sir.
My lord,
You see,
short,
apana
short date, my lord.
affidavit flag AB re achi.
My lord,
Scan karibe na,
I can
update
serve a
update.
copy right here if my lord wants to peruse.
No. He has got it, but it is not scanned yet, and it is not reflected in
My
the.
lord may kindly,
It's not reflected in my brief.
if my lord can consider today itself. So.
No. Affidavit is there. Affidavit is taken on record. That's fine.
My lord.
But copy has been. ଆପଣ ଏଟା କେବେ ଫାଇଲ କରିଛନ୍ତି?
Yesterday, my lord.
Okay. Mr. Pratik Naik for the petitioner, Mr. Devasis Naik AGA for the state. The learned counsel for the petitioner submits that he has filed a memo with affidavits filed by the bailers, local bailers, by local persons. Affidavit along with memo along with Katinal author lekhontu. Who will stand surety in case the court considers to grant bail to the petitioner. The said affidavit filed in the registry on 21/11/2023 shall be scanned and the case brief shall be updated. এই যেটা affidavit এতে কি advocates clerk ফাইল করছেন?
My lord.
আচ্ছা সে নিজে ফাইল করছে। কোন লিখলে? Shall be updated. Copy of the affidavit filed on 21/11/2023 এটা কোন সে নেকি দেবে না আপন স্ক্যানিং করিবে? পড়ে যে কি হবে? So has been served on the learned DG who shall obtain instructions regarding the contents of the affidavit. Contents oblique veracity of the statement made in the affidavit. The learned AG is also requested to obtain instructions regarding the conditions that have to be imposed in case the court grants bail to the petitioner. The petitioner is a foreign national. List on आज कितने ला 22 list on 8/12.
One more thing, my lord.
Yes.
In the first time when I had presented this case, my lord had asked about certain conditions. One condition my lord had asked about clarity was regarding its jurisdiction, because he was arrested from Delhi and Baleswar police. So my lord, I want to clear one thing in mind, that Baleswar police, with the help of Kishanganj police in Delhi police, they arrested him. So if jurisdiction has to be set, then Kishanganj police station, New Delhi, will be its jurisdiction where he can appear once in a week or one every day, whatever my lord may deem fit.
No, that will be both conditions are there.
My lord.
When somebody is staying at different places inside India, then he has to report to the local police,
Right.
and also cooperate with the police of Odisha whenever they require.
That is
Both
what
have
I'm
to be there.
my lord.
Both
That
have to be there.
Kishanganj and Baleswar police were the men, and Kishanganj is his jurisdiction.
Does he have a place of stay in India?
My lord, he is working as a Christian missionary in a church since 5 years.
Where, sir?
In Delhi,
Place.
in New Delhi, sir, in Kishanganj, along with his brothers. They are just Christian missionary. I had explained his role, how that Facebook worked. My
You
lord.
also, Mr. Naik, you also inform the obtain instructions from the local police regarding the flight risk.
My lord.
flight risk and his antecedents. The learned AGA shall also
In the
obtain,
FIR, prime
instructions
accused
from
are
the
mentioned.
Kishanganj Police, Delhi. You are sure about the police station being
My
Kishanganj?
lord, it is written in the charge sheet. I'm submitting from the charge sheet.
Kishanganj Police, Delhi. Through the local police, from the DCP, from the concerned DCP of Delhi, regarding the place of residence of the petitioner and past allegations of criminal activity, comma, if any, against the petitioner during his stay at the said place. So let it come on 15th. Mr. Nayak, to 15th.
My lords, I have noted it. I'll try to.
Yes,
get
you
it
try
as
to.
early as possible.
It case.
No, next.
Item 19.
Obliged, my lord.
Yes. Is that where reinvestigation was directed?
Yes,
Is it that case?
ଆଜ୍ଞା ତାଦେହରେ ସେ ଡାଇରେକ୍ସନ ଆଣି ଫେବୃଆରୀ ମାସକୁ ଆମେ ଆସିକିରି ପହଞ୍ଚିଲୁ ନଭେମ୍ବର ଏଣ୍ଡରେ
They admit, Mr. Mahapatra, fairly that it was handed over in May. They admit. The order in February was complied with in May, as far as they are concerned.
who is responsible? I am in custody, and it is also duty of the state to see that it should be investigation should be completed within reasonable time. And I am in custody more than 5 years without any trial.
The best evidence कौन अच्छी? Clinching evidence कौन अच्छी?
My lords,
Circumstantial evidence.
one witness.
73 and 27/9/2023. The learned AGA has produced instructions from the. He's the IO.
My lords, he's the
From the investigating officer, comma inspector of police, comma CID, comma CB. So he has written in bracket IO, comma Odisha, comma Kotak. Vidate DR, D capital R capital dash 14894, dated 07.11.2023. The said instruction is taken on record.
My lords.
Having heard the learned senior counsel submits that the petitioner is in custody since
19/1/18.
19/1/2018, when the matter was investigated by the police of the jurisdiction where the occurrence happened. Thereafter, as directed by this court in WPCRL,
CRL MP number.
in CRL MP number 498 of 2019, comma, order dated 16/2/2023. The investigation was handed over to the CID, comma CB. The said petition was filed at the instance of the informant. Para. The learned senior counsel highlights the period of incarceration. And further submits that. And submits that the petitioner is to be shown indulgence as far as grant of bail is concerned. By referring to the the materials discovered in the investigation. Because I can't. It bond achi to? Yes. It is further submitted that the petitioner, being a local resident, shall subject himself to the jurisdiction of the learned court in session of the matter and shall abide by all the terms and conditions that would be imposed for grant of bail. Para. So, the period of incarceration likely nahi, which is about 5 years and 11 months. About 5 years and 11 months. The learned AGA, referring to the case diary, opposes the prayer for bail. Para. Having heard the learned senior counsel for the petitioner, the learned AGA for the state, the court is inclined to grant bail to the petitioner subject to such stringent terms and conditions that would be imposed by the learned court in session of the matter, disposed of accordingly. I'm going to receive koriki, record enclose.
Item 20.
So, Mr. Standing Counsel and Mr. AGA, maybe if some lesser offense is also attributed, he has served more sentence.
Yes.
Yes. Yes, Mr.
Item
Pradhan.
20.
Yes, in item 20, let's today have filed interim application.
Yes.
Okay. For grant of interim bail. And because mother of the
Today you are filing affidavit, serve a copy, let them take instruction and
mother of the petition has expired on 20th. Today is the third day.
Okay, so they will get this. They are usually getting.
Yes, that's why I pray, my lord. Today there are 3 matters: item 20 and 45 and 47.
This is which item?
Item 20.
20.
BLAPL 7973 of
20.
2023.
The other one is?
Other one is 45 and 47.
Okay.
All 3 matter I pray.
So you file separate petitions or?
Yes, in all 3 cases
all
I have
cases.
filed. So I pray, my lord, these 3 matter can you taken out tomorrow along with my IA?
No, you filed that IA.
I have already filed. I have I can
24th ani paribe na 28th ani instruction.
No, I have given all these certificates, death certificate, everything.
Sir, phone kori chesta karantu. Chesta karantu.
Bro, over phone they can
Tomorrow we will get it.
And ne 24 re mu rakhuchi. Can I yes no he ki can I file return hobani should for list hey paribe. So many issues are there.
On telephonical will get. Of IMA kind.
The
officer already solved another
DLFL lekhantu. But 20 je order 45 re 47 re sit order. In 45 and 47 who is appearing? Who is the learned counsel appearing?
State council.
No.
Myself, I am. All 3 cases. All 3 I am.
20 Mr. Vishnu Prasad Pradhan for the petitioner, Mr. Devasis Naik AGA for the state. Mr. Standing Counsel, you can get it by tomorrow.
Yes, sir.
Tomorrow can we?
Yes.
So you make a mention by 2 p.m. tomorrow if it is not reached. So list it tomorrow. Tag kori ki de debe. List kar do. Apna last evening re deben. नहीं 4टा बेले भी अपन देले होबा अपन तो दौ नांती बोली प्रॉब्लम ना हो अपन तो
Even if my lord may kindly keep it to after launch, my lord.
ए काली आसु
Yes.
the IA number ta
I number मतलब 1544
in
23 I number 1544
in item number 20.
Yes, in item number 20.
45 re
in item number 45 I number 1546 of 2023.
47
I number 1550.
Okay. IA lekhantu 1544 of 2023. The IA has been filed by the petitioner on behalf of the petitioner stating that he will be attending the obsequies of his mother who has unfortunately passed away on 20th of this month. The certificates regarding the demise of the mother have been enclosed to the IA. Copy of the IA has been served on the learned counsel for the state, who shall obtain instructions. List tomorrow. The registry shall update the case brief by scanning the copy of the IA. You have already filed or you are filing today?
No, I have already filed. Number I have filed.
Yes. We'll update the case brief. Scan copy of the case brief by including the IA. Same order in 45 and 47. 45, 47 file ta kadi diyontu ebetu. Yes. Next, please. Mr. Paul.
21.
Mlan Shakti Paul for the petitioner. Mr. Devasis Naik AGA for the state. Yes, Mr. Paul.
May I please, Lord? My Lord, as per order dated, my Lord, 1/11/2023, my Lord.
Yes.
I have filed a affidavit of the father of the petitioner, my Lord. Here is a case, my Lord, where the 27 years young boy is in custody since 29/5/2023, my Lord.
How to contain him? How to contain him? He has become law unto himself.
Yes, my Lord. My Lord, kindly have a glance to the
remanded ketara case re arrest hichi ketara case.
My Lord, in all the in this mentioned case, my Lord, in this case he was arrested, and other cases were the prior to this case, my Lord. My Lord, these are the previous cases, my Lord.
Yes.
And this is the present pet. In the present case, he was been arrested and remanded, my Lord. My Lord, here, my Lord, the father of the present petitioner.
Here, this information is matching with your,
my Lord.
Or maybe he has, I mean, just simply reproduced your.
My Lord,
no, that is better because they are taking a risk by that.
Here, my Lord, the father of the present petitioner filed an affidavit, my Lord. Kindly have a glance to the affidavit, my Lord. The dated affidavit dated, my Lord.
Flag A or flag B?
My Lord, flag B, my Lord.
B. That is 2011.
Yes, my Lord. In the second, my Lord, second page, my Lord, it was in paragraph number, my Lord, 4 and 5.
Here the ଆପଣଙ୍କର ଏପର୍ଯ୍ୟନ୍ତ ଯେତେଟା ଆପଣଙ୍କର ଯୋଉ ମାନେ allegations ଅଛି, so highest କୋଉଟା?
That is only
NDPS ରେ ବି ଗୁଡେ ଅଛି ଆପଣଙ୍କର?
No, my Lord.
NDPS ରେ ଗୋଟେ ସେଟା?
ଆଜ୍ଞା, ଗୋଟେ. And my Lord,
Arms Act ରେ ବହୁତ ଅଛି.
My Lord, that's yes, my Lord. There are year-old cases, my Lord. What
କୋଉଥିରେ କିଛି condition ଥିଲା କି after being released on bail you will indulge in such similar criminal activities?
No, my Lord.
ସେମିତି condition ନଥିଲା ତ?
No, my Lord.
କାହିଁ ସେଟା? Then you are misutilizing the liberty.
My Lord, I have given, my Lord, the affidavit, my Lord. The father of the petitioner, it is specifically written in paragraph number 4. That I swear this affidavit stating that I will held
that condition I'm imposing, that the family member shall be a bailer, that I'm imposing. In this case, it has to be there.
Yes. Charge sheet has been submitted.
এই কেস ରେ ସେ ଯୋଉ ଧମକେଇ ଥିଲେ ତାଙ୍କର girl ର would be husband କୁ ଧମକେଇ ଥିଲେ, this is the case.
Yes, my Lord. Yes, my Lord. Not girl କୁ ଧମକେଇ ଥିଲେ, ଝିଅ କୁ ଧମକେଇ ଥିଲେ.
ନାଇଁ ତାଙ୍କ family କୁ ଯୋଉ ଧମକେଇଛନ୍ତି.
ଆଜ୍ଞା, ତାଙ୍କ
ये तो
the father has given the affidavit, he will held responsible, and he will, my Lord.
The allegation is that he fired a blank fire he made, and he directly threatened the girl and her family that he'll kidnap the girl.
And meantime, the girl has been married, my Lord.
I understand if they are saying actually the girl could marry because of the intervention of the police and he being a state guest.
And the father
otherwise, he would have made the life the girl and the invitees to the marriage their life hell. Only because he has been made a state guest, so that is how the marriage could take place.
Yes.
4, 5. But only consideration is that at his age, he is going to be more hardened. That's the only.
Already.
His father is at least much younger to me.
Yes.
See what the plight of the unfortunate father.
3 307s out of 8. Out of 8 CAs, my Lord will see that there are 3 307s. And then the rest are of arms act.
But my lord, in this case, 307 is not made out. Blank firing, my lord, there is no
Wait
injury,
and
nothing else, my lord. This type of cases.
ସିନେମା କରୁଥିଲେ ନା ପୁରା କେତେ ଦିନ ରହିଲେଣି ଏଥିରେ?
My lord, 29/5/2023, and charge sheet has been submitted on 27/7/2023. More.
Apart from the conditions that how to contain his activity, apart from the condition that his family member or father will stand as a surety.
He has to come to the police station and whatever weapons
No.
he has, that he has to declare and deposit. Unlicensed, but it has been recovered.
Unlicensed.
License thibo. But how is it at least that condition may be there.
And Bhubaneswar, the supply could be from Munger.
That's the most likely place.
Because after closure of the ordnance factory at Munger, actually the persons who were working,
My lord.
like this Jobra workshop, all those persons who were working in that shipbuilding, repairing and building yard, so they started on their
They have
own.
created their own workshops where they are manufacturing these country-made revolvers and pistols.
So whatever terms and conditions they will be imposed after hearing apart from these three conditions. About licensed weapon ଅଛି କିଛି?
No.
Mr. କଣ ଲେଖିଲେ? ଦେଖିନାହାନ୍ତି? Mr. Amlan Shaktipal, Mr. Devashish Naik, that petitioner is in custody since
29/5/2023.
29/5/2023. The final prosecution report in the present case has been filed on
27/7/2023.
27/7/2023. It is submitted considering the period of incarceration and the fact that the FPR has been filed. The petitioner is to be shown indulgence as far as prayer for bail is concerned. Para. The Learned Counsel also refers to the affidavit filed on behalf of the father, filed by the father of the petitioner, and submits that though there has been past allegations of criminal activity against the petitioner, if he is granted chance to come back to the mainstream of the social life as stated in the affidavit of the father dated 20/11/2023. It would help the petitioner in reforming himself. Para. So para, it is submitted that Tanka submission note question. It is submitted that the petitioner, being a local person, shall subject himself to the jurisdiction of the court in session of the matter and shall abide by all such terms and conditions that would be imposed by the learned court in session of the matter for grant of bail. The learned AGA, referring to the nature of allegations, the materials contained in the case diary, and the past allegations against the petitioner, opposes the prayer for bail. Stop. However, the fact of filing of the FPR is not disputed, and it is also submitted that the affidavit, the contents of the affidavits filed by the father of the petitioner is in sync with the police report regarding past allegations of criminal activity. Having heard learned counsel for the petitioner, the learned AGA, and considering the material on record, the court is inclined to grant bail to the petitioner subject to such stringent terms and conditions that would be imposed by the learned court in session of the matter. We shall also include the following conditions. First of para, number pokantuni, first of para, that the family member of the petitioner, there shall be two sureties. for grant of bail, one of whom shall be a family member of the petitioner, to next up that any violation of oblique deviation from any of the terms and conditions that would be imposed for grant of bail shall result in filing of petition by the informant oblique victim oblique law enforcement agency. The copy of the affidavit filed by the father of the petitioner dated 2011-2023, filed by the father of the petitioner before this court dated 2011-2023, shall also be produced before the court in session of the matter to enable the learned court to consider the same for imposing any terms and conditions. Yes. Even they direct that every day you will be present at police station, that I am not going to modify.
Yes.
The learned court shall impose condition if it after hearing the learned counsel for the petitioner and the learned public prosecutor for the public prosecutor. Stop. Disposed of accordingly.
Item 22. May I please, Your Lordship?
Mr. Standing Counsel, you also explained that regarding cancellation of bail, because they have to straight away come here and file it.
Yes, ma'am.
Because at times the repetitive offenders, allegations.
Sometimes we are doing it, my lord. They are
Yes,
coming straight away and
because-
without any,
yes,
my lord,
yes.
sanction, we are doing it.
Yes. No, because liberty granted.
Here,
Because the liberty granted,
It will be very-
nobody can refuse or nobody can grant further
Yes, ma'am.
sanction. Whatever. I mean, even in other matters, the Advocate General once decides that it can be done.
Yes,
Generally, but in these matters, the leave is granted already.
my lord.
Yes.
It will be very.
So that is how I say that is unusually harsh, because they can't move the learned court below for any grant of bail. 439 is precluded now. Yes. Yes, next please.
May I please, Your Lordship?
Item 22.
You have Mr. Singh.
B. Das.
Mr. B. Das for the petitioner. Copy of the depositions you have served on the state.
My lord.
Upon kebe serve kolegi. Then how it will be updated?
They have been hostile, my lord.
Did not support.
They have been hostile, my lord. They did not
Whatever,
support.
sir. I am not saying whether they are hostile or supported the prosecution witness.
Sir,
How I will go through and how they will go through.
my lord.
No, that's not it. That's not done. That's not done. Mr. B. Das submits that in terms of the earlier order. The order was passed on 3/11.
My lord.
You
My
have
lord,
taken-
today I have received, my lord.
So then the court is responsible for that.
My lord.
The learned counsel for the petitioner submits that in terms of his submissions as noted in the order dated 3/11/2023, he is filing the copies of the depositions today in court. Copy of the said depositions is also being served on the learned counsel for the state to enable him to go through the same and obtain instruction. Is how much time, Mr. Standing Counsel?
My lord, they will also next week.
Aji kete hela? 22. As prayed for,
24, my lord.
list on 28th. No, the court is not at Baker. They can call up somebody who is not interested to take seek indulgence. Then why the time was granted on 3rd? It could have been dismissed that day also. Why the court granted you time on 3rd and this petition is filed? Deposition of date kebe? Date.
My lord.
14th.
Date kebe hela?
14th.
14/11.
My lord, actually, I received today, my lord.
Obviously.
Just the plan.
So there don't take the court. Sir. This is not the court's concern that when you are receiving, who is receiving. The question you have not filed. What likely? সেটা কোন সেটা এটি দেই হবে না ଆପଣ କାଚ ଭାଙ୍ଗିବେ ନା କଣ ଆପଣ ଏଟା ମିଳୁନି ଜାଣିଛନ୍ତି এটা ଅଷ୍ଟ୍ରେଲିଆରୁ ଆସୁଛି
Item 23.
in fact after I said that I'll be sitting in paperless court they took 3-4 months to get this Wacom. It is not available. The other screen is available but Wacom, this touch screen and all that, it is not available. There's only one manufacturer.
Much pleasure.
But I think is immediately register file karantu. There is already an order to they will update it.
My lord.
Yes, may it please the Lordship, my Lord.
You have this affidavit you have served on Mr. Palli.
Yes, it is served, and last occasion some technical glitch happened, so she and State Council.
For the petitioner, Mr. Standing Counsel for the State. The learned counsel for the petitioners seeks further accommodation to advance arguments as prayed for list on 15th of December 2023 to grant further opportunity to the petitioner. Case diary has been received.
Yes, sir. Up to
The
date.
learned standing counsel submits that case diary is
And
available.
get the up to date case diary.
The learned standing counsel shall obtain up to date case diary. Yes.
Item 25.
Yes, please.
Pray for 1 week after, Lordship.
You are Mr. Bhanja or Mr. Behra?
Behera.
Mr. B.K. Behra for the petitioner. Mr. Standing Counsel for the State. Learned counsel for the petitioner seeks further accommodation to advance arguments as prayed for list on 7/12/2023 to grant further opportunity to the petitioner. The learned standing counsel shall obtain up to date case diary.
No, trial started, he has given some depositions. Let him come with the.
The learned counsel for the state shall obtain copies of the depositions, if any, of the PWs to substantiate his arguments. To substantiate the prayer for bail. Copy of the depositions, if any, shall be served on the learned counsel for the state. Yes.
Item 26.
Your Lordships, on behalf of Learned Counsel, Mr. S. Harichandan, I'm praying to take up this matter next week.
Your name, sir?
Amlan Mahanti, Your Lordship.
You have no power here.
No, Your Lordship.
Mr. A. Mahanti, on behalf of S. Harichandan, for the petitioner, Mr. Standing Counsel for the State. The learned counsel for the petitioner seeks accommodation to advance arguments. Further accommodation to advance arguments.
CD is not there.
Wanted?
Yes.
Okay. As prayed for list on 13th of December 2023.
Your Lordship.
The learned standing counsel shall obtain up-to-date case diary, public instructions. Yes.
Obliged.
Yes, madam?
May I please, Your Lordship?
Yes.
My lord, in this case,
My lord, 27 and 28, my lord, belongs to the same petitioner.
Yes.
He is having 20 criminal incident. Let him file. I will get the CD. Let him file the affidavit.
The other FIR, what is the bail is pending? FIR 366. Pradhani Jani, what is the implication of Pradhani Jani here?
Raghunath Behra.
Raghunath Behra. Yes. Ida. When similar matter order kichi hai jani to, I cannot take up then.
My lord, in this case, my lord, no, my lord,
I mean, out of those 20 cases, nowhere the bail appeal has been considered by any other coordinate bench.
that since separate PS cases are there, your lordship.
No, same PS case, no, okay.
Yes. Because, my lord,
You are Miss Behra.
yes, ma'am.
V.R. Behra. Again?
Sakuntala Ghosh.
Miss Sakuntala Ghosh, M.S. Sakuntala Ghosh, on behalf of S.K. Nath for the petitioner. The learned counsel for the petitioner shall file affidavit on behalf of the petitioner indicating the past allegations of criminal activity, if any, the present status of each of the case and the amount involved. If the similar allegations under section 420 of IPC has been made. The registry shall again put up note in terms of the earlier order dated 13/10/2023. So, the registry shall. The purpur date de diyo. Registry shall do the needful kon likhle. put up note in terms of the earlier order dated 1310 regarding the FIR detail match. Referring to all the BL appeals. Yes. Upon affidavit deontu regarding past criminal activity of the. That is how these matters are being handled in this court. Janchanti na nahi?
Yes, madam.
Yes, do that and serve a copy. Copy of the affidavit be filed. How much time?
Sorry, madam.
How much time you will take to file the affidavit on behalf of the petitioner?
1 week.
The affidavit be filed by 1/12/2023. Copy be served on the learned counsel for the state to enable him to obtain instruction. List in December.
Yes, madam.
Second week Redion. 14/12. List on 14th of December.
28.
Obliged, madam.
Yes, please.
28, my lord. Another case, my lord, same petition.
Same order tale. Again. Yes, Miss Ghosh. Nahi kon? Nata kon na? Shakuntala Ghosh. Yes. Apanko 28 ta bi apanko.
Yes, madam.
Same order. Apane 28 ta out a FIR.
Out.
Acha.
Another person has been cheated.
Okay. Say 420.
So chakir.
Miss Ghosh, please appreciate. Right now, in fact, there are 2 cases. So, as per the orders passed by this court,
20 cases.
20 cases are there.
My lord, total 20 number of cases.
Upon detail diyantu, upon kon korchonti, ote list kariki de dochonti. Sethiru kon bujha kon padibo. Upon status debe, that much of effort has to be made by the petition.
Cases has been bailed.
Whatever. Bail jo condition thila, he will repeat of such offences. Na kon. That goes against you. Whenever you are granted bail, you are repeating the offence. दियंतु से स्टेटस ता दियंतु सेटा तापर आ गोटे तार जदी कोटे अन्य बेल ऑर्डर हेतिबो ताले सेटा भी फिर से ठीक जीवो एनीवे सो रेस्ट ऑफ द मैटर्स आफ्टर रिसेस एनी मेंशन मिस्टर
88 not likely to reach early
88
any day next week or any day in fact
88 but for hearing matter it will go below the towards the end of the list. That I cannot interfere.
Sometimes it reaches little
yes.
Immediately after lunch. Sometimes
because lot of adjournments. Kebe kahile 9/12. 9th of January.
No, any day.
Yes, 9th of January 2025. 24.
Because it is ready for hearing.
Yes.
Item 66, my lord. You should turn to lots of page 8.
Yes.
Item 66, my lords.
Yes.
An affidavit has been filed if it is regarding or pertaining to the welfare, the well-being of the opposite.
Most likely.
I may permitted to see the records, so they can.
66 re de debe kichhi asubidha nahi apan no dekhle bi chalibo because since it is paperless so they are not that much interested to bring the files in. Don't worry for that. I'll take care of that. Yes, Mr. Mahapatra.
No, item number 80, my lord. The sole petitioner died, my lord.
Memo ta deuchandi supported by a certificate.
No, simple memo.
Okay, I'll go by the memo. Yes.
Now.
Yes.
76 minute hearing matter. I am praying for.
Kete number subilani.
76 minute.
76. Yes.
Hearing matter. I am praying for minute time.
76 ta date kar diyo.
8 My lord, 29 I am praying for.
8 है एक Mr. Ponda.
Oblate.
24. Again?
My lord, 29 I am praying for an adjournment.
29 to? Bail take wait karantu. Your colleagues are there. They are waiting. Apno out of turn kimti korchu. I have to pass that order. If you have any difficulty, kahaku inform karantu. Tell someone to. Yes. Thank you. Patnaik.
Use the microphone. Microphone.
So affidavit stating that he has passed away.
Date, can you mention the date?
23/8/2018
Okay.
at Apollo Hospital, Bhubaneswar.
So this submits.
Yes.
Then the second matter, Mr. Patnaik, you are there.
Yes, ma'am. I'm the opposite party number 1 there. The petitioner is the informer, the informant. And here also, I've also filed his death certificate.
He passed away.
Passed away.
So informant, so he may come at after, since it is taken out of. So the same said that will be noted here also. The same flag A affidavit. Okay. Yes.
So Lordship, dispose the item 66, no? CRLP.
66, first one is disposed of.
Yes.
But second one, let Mr. Digambar Misra come. Because in his absence, passing that order will not be. Because
So CRLP 85/2007 dispose of as abated.
Yes.
Appropriately, it will dismiss as abated.
Yes.
That's our item 15.
None appears for the petitioner, though the matter is called twice over. Once when it reached, and again after resumption of the court proceeding, after the lunch break.
Here, my lord, only report was called for. Matter was disposed of. That's why.
Oh, I'm sorry.
Yes. Well, that report.
The petition was disposed of. The petition was disposed of. The petition was dismissed by order dated 17/10/2023, rejecting the prayer of the petitioner for grant of bail. Stop. However, a direction was issued to the opposite party state to obtain instructions from the by inquiry through an officer not below the rank of SDPO regarding threat perception, if any, against the petitioner after which a stop. Report as
No, my lord, that has not.
The learned standing counsel seeks further time accommodation to obtain the said report after inquiry. Yes.
10 days after, man.
As prayed for.
11/12.
10 days for 11/12. 11th of December.
My lord.
Date पकेलेनी date पकेड़. Yes, next.
Item 29.
My lord, I pray for an adjournment.
You have Mr. Kanungo.
Sarthak Mishra.
Mr. S. Misra, Estate Misra for the petitioner. Mr. Standing Counsel for the state. 161 को introduce कर दे लेटे 164 inadvertent typographical error has crept in the order dated 5/10/2023 where the section mentioned should be read as 164 of CRPC instead of 161 of CRPC. Accordingly, the order shall be corrected, replacing 161 in the third line as 164. Yes. The Lord and Counsel for the petitioner seeks further accommodation to advance arguments as prayed for list on 18 December 2023.
My lord.
Here the case diary is available.
Yes.
The learned standing counsel submits that the case diary, including the statement of the victim,
Yes.
recorded under section 164 of the CRPC, is available. Yes, next.
30. May I please?
Yes, Mr. Dipti Ranjan Bhokta for the petitioner.
Here, my lord.
Yes.
Lordship
case of
directed
three-
them to produce the 164
Yes,
statement.
my
They
lord,
have
that
taken
164 statement
sufficient
has come. Cities has come, my lord. That 164
Mr.
statement has come.
time and again. Your Lordship can see time and again.
Time and again, if they take time, I will grant bail.
No, that is not my plan.
So they don't intentionally do it. There is
No, no,
difficulty.
what-
Mr.
What
Bhutta,
happened, my lord? Your Lordship can see he's inside the custody for 6 months, my lord. Victim has denied for medical
were you present here in the morning?
No, my lord.
A person exactly after 6 years, he is still incarcerated. It is investigated. So no right accrues for grant of bail because they have not been able to.
That I am not praying.
So
That
then
never I'll pray that.
obviously, so you have to be less anxious than whom? Less anxious than the person who is inside custody.
Custody.
सीए कस्टडी रे अछंती बोली बाहर पे anxious. आपण bail move कला बेले anxious. So court has no option but then to reject it on the आपण को favor रे जते बेले गोटे positive direction
Yes,
जाउ
I only pray, my lord. Let them obtain 164 statement as a last chance, your Lordship direct, because
last chance I never grant. Last chance I never grant. If it is, if your submission should be, this is the only offense committed in the said particular thana and is the only case. Then I will grant. In fact, I will allow the petition.
On 28/8, since 28/8, they are taking time, and victim also denied for medical examination.
Denial of medical examination should be acquittal. A grant of bail. Then when medical evidence is not corroborated, is not tallying with ocular evidence, कौन होगा?
Your ocular evidence.
Ocular evidence यदि है, the statement है, then medical evidence can also be rejected.
Discrepancies in the ocular evidences, my lord.
Whatever.
He's having another criminal incident, let him file affidavit.
Note that I have already annexed, my lord. That is not criminal antecedents. The same lady has filed the FIR.
Padua PS case number.
Yes.
Sita kuchandi.
And your Lordship kindly see, I approach this honorable court in the anticipatory bail application. The State Council has stated that in this case, 41 has been complied.
Mr. Bhutta, the State Council is not targeting any petitioner for that.
No. Your Lordship kindly see, I have annexed the order.
So how does it matter for 439? If your submission is if before 438 application, such a submission is made, 439 is to be allowed. Then I can reject the petition.
No, 438, they stated that 41 has been complied. I praise that no, 41 has not been complied. In spite of that, they stated that CD is available, 41 has been complied. There is no apprehension of arrest. In spite of that, I have arrested. They have arrested.
There are several instances. Several instances. Today the matter is pending since February, directed by this court. You are talking about the investigating agency.
Here, in the present case, my lord, no 41 has been received, my lord, due to some mistake, my lord. In another that previous case, my lord.
The earlier matter.
Yes, my lord.
Or earlier BLFPL.
Yes. That in that.
So, bar of 2022.
Yes, it is submitted by the Learned Council for the state that the investigation has ensured the provision 41 as CRPC.
We'll go for my lord cancellation. Go for. I'll write my lord for cancellation.
Yes.
That 41.
That sheet has been submitted.
Charge sheet submitted, and subsequently the lady has filed another case but has not disclosed about this case.
Res judicata ki apanଙ୍କର?
No. Though
Balakrishna jane athyanti advocate se res judicata puri argue korthile.
Though this incident.
Res judicata in case of 376.
No, though this incident was taken prior to that case, and he has stated 3
Whatever.
days.
How does it matter? ଆପଣ ସେଟା ମାନେ ଯେତେବେଳେ କ୍ରସ୍ ଏକ୍ସାମିନ୍ କରିବେ ଆପଣଙ୍କର ଆର୍ଗୁମେଣ୍ଟ ହବ ଆପଣ ସେଟା ପ୍ରେଜେଣ୍ଟ କରିବେ.
Let them obtain 164 statement, Lordship. Sufficient time may be given.
Sufficient time or what? That's none of your concern. That's none of your concern. But your argument, if you want, I can reject it by observing that since 164 statement has been not produced in 28/8/2023, the petitioner is deserves to be enlarged on bail by making a in 439.
No, that
I can reject. ସେଥିରେ କ'ଣ ଅଛି କି? So ସେଥିପାଇଁ କହିଲି ଯେ you have to be more patient than the person. ଆପଣ ଯଦି impatient ହେବେ କେମିତି ହବ? Court whenever it wants to go through the 164 statement, is there any presumption that the bail will be rejected? No. Then why you are so anxious? In none of the petition I am finding the petitioner's counsel is proactive. 10 thar adjournment hela par affidavit diya habo.
No. In some cases,
affidavit diya
yes, we are also committing mistake.
No, it's not mistake. ଆପଣ ତ ସେଇ କଥା କହିବେ ସବୁ ଜିନିଷକୁ ରାଇଟ୍ ବ୍ଲାକ୍ ଆଣ୍ଡ ହ୍ୱାଇଟ୍ ରେ ଦେଖନ୍ତୁନି ଆପଣ ଭାବୁଛନ୍ତି କଣ ପିଟିସନ କାଉନସିଲ ଭୁଲ କଲେ नो not that way. Mr. Bhukta learned counsel for the petitioner submits that despite repeated adjournments the statement of the victim recorded under 164 statement 164 CRPC CR.P.C has not been produced. The learned standing counsel seeks further accommodation as prayed for list on 14 बार नो आगे अपन कोड देखछन कैलेंडर 4/12 4/12 और फर्दर टाइम मिस्टर भुक्ता
11/12 को
11/12 अपन कोन जे रहि जिवे कि सेठी
नहीं
भागर अटेंड कला पर कोन आसीबे नि
29 रे बागर अछि 4 तारिख रे आउटे यूनियन ऑफ इंडिया रे उटे मैटर लिस्टिंग अछि हियरिंग चीफ जस्टिस कोर्ट रे
11/12
से रही 29 रे जाकी 29 रे फेरी आसी वन ऑफ आवर एसोसिएट्स
नहीं फाइन नहीं अपन को बर्तन चल छी कहले अछि अपन एटा बंद अछि त those interim bail application I am listing it on tomorrow.
Yes,
Often the
I've already informed.
Okay.
Yes, here in this case, I have also filed and my name has been enlisted. Copy served. My lord, here in this case, the one FIR has been registered in the year 2023 in connection to the transaction of the year 2020. The allegation is that lodging of FIR, my lord. Here in this case, the informant has lodged this FIR. No. It is my duty to submit for this court about the fact. Correctness of the fact. My lord. My responsibility. Money to the accused to provide a job in government sector in the year 2020. My lord, I have also filed the affidavit. No similar antecedent, my lord. The petitioner is behind the bar since 34/2023. In the meantime, more than some in the charge sheet has been already filed on 26/2023. An investigation has already completed.
That affidavit filed by him.
Yes,
आपण मोथा सुनी पर नथले कि मोर आगोटे बंद बदे कर देथिले. I'm sorry. That is in sync with your instruction.
Apart from my instruction, he has given one more criminal incident. I am thankful to my friend. And my lord, he has taken, my lord, around 10 lakhs, my lord, from the present, from the informant, through, my lord, bank account, phone pay, and, my lord, cash transaction. My lord, 10 lakhs has been taken for providing job, and also, my lord, in railway and also ASO. And by that way, my lord, the
ASO High Court.
Language say,
My lord, there is no deceitful inducement by the committed by the accused But
ଆଜ୍ଞା ସେଇଟା ଟିକେ ସହି ସମ୍ଭାଳି କୁହନ୍ତୁ ଆଜ୍ଞା
only
even sir a person ଆପଣ just ସେ ଯୋଉ ଯୋଶୀ
My lord.
judgment ପଢନ୍ତୁ even they have been held guilty.
My lord, here in this case, the informant alleged that I have paid the amount to somebody else. There is no
Maharashtra Public
documentary
Service
evidence.
Commission chairman
My lord, she has paid.
ଆପଣ ଶୁଣନ୍ତୁ ଆପଣ come to the have you seen the trend of orders in these matters, past orders starting with Justice B.N. Mahapatra. He has retired long since. You take instruction to seek indulgence of the court how much money you will deposit.
My lord, he has
Unless you take that by telling him that the court was the deliberation in the court was like this, he will not listen to you, because everyone who has swindled money, maybe 1 crore or 21 lakhs, 50 lakhs, they have become pauper.
Exactly.
By the time they are arrested.
My lord,
So whatever is the reason, so that is not cutting any ice.
well, I do admit. But whatever he has stated, the information stated in the FIR is not a gospel truth.
Sir,
He has only-
Mr. Senapati, that's not a relevant consideration. I am not here to convict you or acquit you.
50,000
No, you take that instruction. You take that instruction and file that affidavit. I am inclined to deposit. So
But I am ready to pay 50,000.
file that affidavit. Don't commit on behalf of any client.
My lord.
Always keep that arm's length.
My lord, I have discussed with the wife of the
Discussed.
My lord.
So now see, they have become pauper after swindling the money. Everyone becomes pauper.
My lord, otherwise he will not get bail.
You see, Mr. Senapati, if you would have repaid the loan, then he would not have been behind bar.
The payment of
That's another thing.
My lord, payment of 50,000 is a condition precedent to get the bail.
No, that order I am not passing.
My lord, he has.
I am not at all passing that order.
My lord, he has to deposit the amount.
No, that condition will be there by the learned court in season of the matter. If the court wants cash security or anything, they can impose.
My lord, let the order pass to deposit a certain amount.
No, I am not passing any order. For seeking indulgence of the court, you are making a submission that you will deposit some amount without prejudice to your rights and contentions. So that affidavit you file and take the order. And conditions I am not imposing here. I am allowing the learned court in season of the matter to impose those conditions. Residence spelling bull. Residence of the petitioner in the state of West Bengal through the concerned SP. How much time, Mr. Standing Counsel? As prayed for, list on July 4 is Monday. 5/12/2023. Next matter, you are having instruction.
Yes, ma'am. That has come from West Bengal.
ଅଲଗା ଜାଗାର ରେସିଡେଣ୍ଟ କି
ନାଇଁ ଗୋଟିଏ ୱେଷ୍ଟ ବେଙ୍ଗଲ
ଅଲଗା ଅଲଗା ଜାଗା
ୱେଷ୍ଟ ବେଙ୍ଗଲ ରେ ଷ୍ଟେଟ ଗୋଟେ ଯେ ମାନେ ପିଏସ୍ କଥା ମୁଁ ପଚାରିଲି obviously
ଅଲଗା ଅଲଗା ଜାଗା ରେସିଡେଣ୍ଟ ସବୁ ଗୋଟିଏ Well, he has submitted the affidavit stating that OP number 1 to 4 have no criminal incident, 3 having mallet incident.
3 anti.
As per my instruction, my lord, OP number 2 has got criminal incident. My lord, 3 has my lord also got criminal incident, and 3 has my lord 3 they have given my lord the antecedent, which doesn't my lord another antecedent they have got another 20 cases there. NDPS case they have against
then
OP number 3, my lord. That affidavit your lordship may kindly see.
ଆପଣ multiple जो ଗୋଟେ ପିଟିସନ ଫାଇଲ କରୁଛନ୍ତି କହୁଛନ୍ତି ଓକିଲାତନାମା ଗୋଟେ ଆସିଲା ବୋଲି becomes so difficult.
And the affidavit can be filed, my lord. The affidavit filed by all petitioners, my lord. There belongs to my lord different people. They are different, my lord. But this has been filed by one person, my lord. How could a person say that he is having?
ଆପଣ ଅଲଗା ଅଲଗା ଫାଇଲ କରନ୍ତୁ ଯଦି ପିଟିସନର ଡିଫରେଣ୍ଟ then how can you ଏଇଟା ତ ଆପଣଙ୍କୁ ଷ୍ଟ୍ରାଇକ୍ କରିବା କଥା it should have struck you how you are filing one affidavit.
Lawyers will be yes directed. ठीक है 1 4 no antecedent and 2 रे antecedent ଗୋଟେ ଅଛି ଆଉ 3 ରେ ମିଲର
ସେଟା ଆପଣଙ୍କୁ ଚେକ୍ କରିବାକୁ ପଡିବ ଏବେ you can't rely on
They
that.
have stated 1 to 4 have no criminal incident. Now you have got the instruction, my lord. Petition number 2. Petition number 2 having 1 criminal incident and 1 non-FIR PS case is there. And against petition number 3, my lord, they have stated that
my lord
he has having
stated
3
in order.
criminal
I will
incident.
file the individually.
Those 3,
Sorry,
My lord, reflected in order, I will file individual affidavit in that.
Yes, because it adds to the confusion. ଆପଣ କାହା ବିଷୟରେ କେତେବେଳେ କୋଉଟା କହୁଛନ୍ତି ଦେଖନ୍ତୁ ଜଣଙ୍କର ଘର ହେଲା ଶ୍ରୀକୃଷ୍ଣପୁର ପୋଷ୍ଟ କୁଲୁବେରିଆ ଆଉ ଜଣ ହେଲା କୁଲାଗାଛିଆ PS ଉଲୁବେରିଆ. If you travel from Odisha to then other one is at post Manikpur. So the PS is PS Uluberia PS is same. Then fourth one is Jagacha.
Next date, my lord.
Only the other part is that district Purna no sera Purbo Midinapur. What the Purna Midinapur lekhile. Midinapur ro jane loko au Howrah district ro 3 jana loko. So apon jane kemti affidavit debe kon karibe. The learned counsel for the petitioner seeks accommodation. The learned counsel for the petitioner submits that Amul Ratna Panda, Mr. Standing Counsel, submits that though affidavit was filed earlier in terms of the order dated 17/10/2023, he may be allowed further time. He may be the petitioners may be allowed further time for filing of affidavit on behalf of each of the petitioners separately, indicating past allegations of criminal activity, comma, if any, full stop. Prayer is allowed. Let the affidavits be filed. How much time?
By Monday, my lord.
Affidavits be filed by today is 22nd.
Right.
By 29th.
As well as our local security also they let them.
Se to kouchoni debeni mu se condition rakhle se tankar seti bujibe.
Then
perhaps they are not following what I am saying.
Time will be
because it is for the petitioner to look for that. If the petitioner is unable to comply certain conditions, for that the lawyer cannot be, lawyer has no responsibility. It is for the petitioner to do that. 29, copy be served, list on 12 December 22. ଆପଣଟା କେବେ ଗଲା? ସେ affidavit ଦେଇ ନାହାନ୍ତି କଣ କରିବା ଆପଣଙ୍କଟା ବି ସେଇ ଦିନକୁ ଆସୁ ସେମ୍ ଡେଟ୍ ରେ ଆସୁ ତାହେଲେ ସେଟା ବି କରିଦିଅନ୍ତୁ 12/12 ମିଷ୍ଟର ପଣ୍ଡାଙ୍କର ବି ମିଷ୍ଟର ମୁଳିଆଙ୍କର ବି 12/12 ମିଷ୍ଟର ପଣ୍ଡାଙ୍କର 12/12 ଆପଣ କିନ୍ତୁ affidavit ଦେବେ 29 ସୁଦ୍ଧା ଦେଇଦେବେ କପି ଆଗରୁ ଦିଅନ୍ତୁ କିଛି ଅସୁବିଧା ନାହିଁ ବଟ୍ ସର୍ଭ କପି ଆପଣ ମଣ୍ଡେ ଟା ଛୁଟି ଅଛି 27th is a holiday.
Can you taken up 1 week after, man?
Mr. S.K. Patnaik for the petitioner. Hybrid mode likhiwe. Mr. Standing Counsel for the state. Learned counsel for the petitioner seeks further accommodation for advance arguments as paid for list on 13/12/2023 to grant further opportunity to the petitioner. Case diary asla?
Yes, ma'am.
The learned standing counsel submits that case diary along with statement of victim.
No, my lord. Here, my lord, victim is unsound man. Person. But that's why, my lord, so they
case diary is
record.
Case diary is available.
My lord,
case diary has been received for perusal of the court. Yes.
Everything has been captured in the CCTV. Man. The incident was, my lord, captured in CCTV. Those are there in, my lord.
This happened in a public place.
A bus stand, man. It's a, my lord, on-stand one is moving here and there. My lord, this petitioner has committed all those things.
No, when actually, why did I ask you? When they also take, they seek adjournment, the court also understands certain things. So, yes, case diary is available.
Charge sheet filed.
Charge sheet has been filed.
35. And that, my lord, that CCTV, my lord, unfortunately, that CCTV footage, my lord, has been circulated between, my lord, so many people, my lord.
IT Act is there.
Yes.
So that is why I was asking that.
That's why, my lord,
That how it leaked
that
out.
person who has circulated all those things, my lord, he has been named as the accused here.
That was a CCTV put by a shopkeeper.
In a shop near the, my lord, inside the bus stand, that was there, everything was there. And he has circulated and he has been named as the accused. In spite of, my lord, the statement of witnesses are there, in spite of several, he has circulated all those things. For that, he has been arrested as the accused.
Yes. 7516, 7521, all the connected bill petitions, Mr. Patnaik, filed by you.
No, my lord.
I mean, from your office. You, in the sense, your office.
No, my lord.
Yes.
And on 30th matter, I will check instruction.
I'm sorry?
I will taken up on 30th December.
This is which matter, sir?
35.
34.
35. No, 35 is SR Mulia. Acha, 32 is SR Mulia, then 33, then 34,
35.
then 34, then 35 is
My lord, dismissed and I was directed to take, my lord, instruction. Welfare of the victim, my lord, that has not come.
Mr. SR Mulia, here the petition, the petitioner blank lekhi diyantu.
No.
So the after no 35 रे आपण confusion हेलानी कोन 34 टा कोड आपण जोटा मेंशन करले मिस्टर एसके पटनायक so सेटा अर्जन हे गला आपण पारे केस डायरी अछि लेखिले केस इज अवेलेबल then 35
disposed of
35 mid 7 is the dispose of the कोची कोन
yes, my lord. My lord, it was disposed of 1310 dismissed.
$13.10 पर then there has been another listing on 611.
Yes, my lord.
So that is how I was looking I was unable to understand. But 611 then how the right of audience came to repeat he gala? On 6/11/2023 he has typed up disclosure of matter dato type kar dele order 6/11/2023 the entire order seems to be out of context in as much as after dismissal of the BLAPL on 13/10/2023 there was no occasion तो कौन correction करी काटी की तब लिखचंती तो कोई भी खाता टा नहीं कैसे 6/11 आपण जे डाकी गाना पासो Mr. Mulia, you don't have to be there. 6/11 ର ଖାତାଟା ଆଉ ଇଏ ଆପଣ ସେଠି ଆଉ କି ନାହାନ୍ତି ସେଠି 6/11 ର ଡାକି ନେଇ ଆସୁ 6/11 ର ଖାତା ନେଇକି ଆସୁ and pass over ବି ହେଇଥିଲା ସେଦିନ କେମିତି so standing counsel ସେ appearance କାର ଥିଲା Mr. Naik 6/11 Mr. Devasis Naik was there but that is after the rejection of the bail petition.
Yes.
से ऑर्डर लिखिबे त आसला पर लिखिबे ऑर्डर त अपन छाड़ दियो अपन से 50 सीट को पळांत से 35 टा नेला परे अपन 36 टू नेबे
May kindly be taken up on after.
My lord. My lords. Cases under section 450, 450, 376, 506. And the prosecution studied that, sir. The complaint alleged that on dated 21/7/2023 at about sound শুভনি গেছে।
I'm sorry. Mr. Sahoo, just wait for some time. Let me note your presence, mark your presence, then you can submit. Mr. Durjodhan Sahoo for the petitioner, Mr. Standing Counsel for the state, the Lauded Counsel for the petitioner being present at the virtual court, Odisha High Court at Kendrapada.
My lord.
At Kendrapada, addresses arguments. Here, case diary is available.
Yes.
Yes. Yes, Mr. D. Sahoo, continue.
Cases under section 450, 376, 5.
You don't have to repeat. You must have marked the proceeding. I'm not. I don't want that. What are the offences under which section? Please wait.
My lord. That on data.
অপেক্ষা করুন তো। Charge sheet has been submitted.
I don't have the my lord up to date list.
When? Annual prosecution report केबे submit ହେଲା?
16/9/2023. 16/9.
16/10.
16/9.
16/9/2023.
और केस डायरी केबे करोगी?
Sealed up.
Oh, this is 24/8. So, shall I record or it should be correct? So, this is charge sheet submitted on?
Subject to, my lord may write, dictate my lord, subject to verification by the court.
Yes, yes.
Court in session.
Date टा कहबे सर आउतर 16/9.
16/9.
Sure.
Lauded Counsel for the petitioner submits that the petitioner is in custody since
21/7/2023.
21/7/2023. देखियो. In the meanwhile, the charge sheet, the FPR, final prosecution report has been filed on 16/9/2023. And the petitioner be shown indulgence as far as the prayer for bail is concerned. It is submitted that the petitioner, being a local person, shall subject himself to the jurisdiction of the learned court in session of the matter, and he shall abide by all terms and conditions that would be imposed for grant of bail. The learned counsel for the state, referring to the contents of the case diaries submitted by the investigating agency, opposes the prayer for bail. However, it is submitted that since the charge sheet has it is submitted that the case diary was received earlier prior to submission of the FPR. Therefore, uh, if this court is granting bail, it shall be subject to the verification of the date of submission of the FPR
by the court in session.
By the court in season of the matters. Having heard learned counsel for the petitioner, the learned standing counsel for the state, and considering the material on record, this court is inclined to grant bail to the petitioner subject to such stringent terms and conditions that will be imposed by the learned court in season of the matter, subject to the verification that the FPR has been submitted on 16/9/2023. Apart from the conditions that would apart from the conditions that would be imposed by the learned court in season of the matter, it shall also contain a condition that any violation of public deviation from any of the terms and conditions that would be imposed for shall lead to filing of your name, sir, Karna.
SS Das.
Mr. SS Das. Mr. SS Das for the petitioner. Mr. 7 out a bail order ଅଛି flag କୋଉଟା ଏଟା 9187 9208
7743.
They had opened the earlier matter. Yes, out of the this is a special 2ACC 37 of 2023.
Yes, sir.
PR number, prosecution report number 31 of 2024. ते देखंतु आपण
फाइल टा एक्चुअली मिसप्लेस है
बढ़िया
Year 3723 MB 79 PS case number
PS case टा 2ACC
89/23
भूल ले बोते टैग हे जाई एक्चुअली एटा 2ACC ना एटा PS केस जोटा टैग हे छेटा एक्साइज केस टा 2ACC ले एक्साइज केस हो
आज्ञा सेटा पचार जे आपण बिना फाइल फोन टिपुचंती
नै नै
मु तो सेत पे आपण पचार
देखुतिले आरटा नोमिनेटेड माने तार येटा रेकॉर्ड देखुतिले सेति
the office note indicates that the office note indicated in the cause list records that the order in the BLAPL 7743 of 2023 arising out of the same FIR has been placed at flag A of the brief. On stop. On perusal of the said order, it is indicated that the bail order, the BLAPL 7743 of 2023 arises out of SPL special SPL dot 2 into bracket small a CC number 37 of 2023. Corresponding to P.R. number 31 of 2023-24. Before the learned sessions judge comes special judge Malkanagiri. The then Sapara, the present case pertains to say GR special 37 of 2023 same.
GR special है तो सेटा एटा खाली GR है सेलाई लगे दिछन एटा 376 सेटा होची गंजेई तो स्पेशल कोड एटा भी स्पेशल एटा पोक्सो
सेटा भी स्पेशल 2ACC लिखा है पण कोचंदी पुलिस केस PSL है सेटा होची GR
एक्साइज ले 2ACC PR
स्पेशल जीआर टा समान है जाउछ एठी भी जीआर 37 सेठी स्पेशल जीआर 37
और लिखले सेंटेंस टी पढंतु G dot R dot capital G capital R dot into bracket SPL bracket closed number 37 of 2023 in the court of the additional sessions judge come special judge in the court of ADJ come special judge dash special judge Malkanagiri arising out of M dot V dot 79 PS case number 89 dated 14/6/2023. Therefore, the FIR numbers are actually different. And the noting in the cause list has to be ignored. Nature of offense here is 376 to POCSO.
Yeah.
Okay. Sethipai special case through confusion age. Yes, what do you say, Mr. Das? You are praying for time.
Yes, Lord.
The Lord Counsel for the petitioner seeks accommodation to advance, seeks further accommodation to advance arguments as prayed for list on 15 December 2023. Lord AGA submits that case diary is available.
Yes.
Including the statement of the victim.
Yes.
Including the statement of the victim recorded under section 164 of the CRPC. Yes.
39.
May please.
Affidavit file kale?
Yes, my lord. As per direction of
Kebe kale file?
6/11/2023, I have filed an affidavit on 21/11.
That is how it is not on record. Mr. Amlan Sakti Paul for the petitioner, Mr. Standing Counsel for the state, Learned Counsel for the here. How many antecedents?
Only one antecedent.
Similar, one similar criminal.
It is in sync with say affidavit call for kari hobo. Kebe apna file korchanti?
Yesterday, my lord.
That's very incident. The 24th रे आसु ताले आपण पर इंस्ट्रक्शन अछि सेटा ऑलरेडी
सेटा अछि
आपण कॉपी दैछन तम
यस
से हमर देखि करथिबे
हां स्टैंडिंग काउंसिल फॉर द स्टेट the learned counsel for the petitioner submits that in obedience to in terms of the earlier order dated 6/11/2023 he has filed 12/10/2023 he has filed affidavit on 21/11/2023. Registry shall update the scanned copy. The copy of the affidavit has been Sapara. The copy of the affidavit has been served on the Lord Standing Counsel for the state to enable him to obtain instruction. When do you want, Mr. Paul?
On the 24th.
List on 24.
Yes,
24 of this one.
Day after 20.
Yes, because since he has already served and that indicates your.
I've already got the instruction.
Yes, already received the instruction.
Item 40.
Or you have a copy.
Yes, my lord.
Dekhan. जोटा तांकु देचेंदी सेटा मते देबे अलगा देबेनी हो. What is the nature of allegation, Mr. Paul?
Same.
केते किलो कोन?
It is 56 gram. Set out 21 be small quantity. But
that is also small quantity 21 grams.
Set out 21 gram.
Yes, ma'am.
छप्पन promotion होउछि धीरे धीरे.
100 कोटी उपरु का जीवनी सेटा हला कथा. The petitioner has the petitioner has produced copy of the affidavit that has been filed on 21/11/2023 on behalf of the petitioner through his wife indicating the past allegation of criminal activity against the petitioner. The registry shall update the case brief. Para. It is submitted by the learned counsel for the petitioner that the petitioner is in custody since
Custody since 24/7
2023
and
in the present case, and the final prosecution report has been filed on
15/9/2023.
And the petitioner may be shown indulgence as far as the prayer for bail is concerned. It is submitted that it is submitted that the petitioner, being a local person, shall subject himself to the jurisdiction of the learned court in session of the matter and shall abide by the terms and conditions that would be imposed for grant of bail. Para, the learned standing counsel, referring to the materials contained in the case diary produced by the investigating agency and the past allegations, as well as the provision contained in section 37 of the NDPS Act opposes the prayer for bail. Having heard the learned counsel for the petitioner, the learned standing counsel, considering the material on record, as well as the age of the petitioner is kete?
33 years.
Being aged about 33 years, this court is inclined to grant bail to the petitioner subject to such stringent terms and conditions that would be imposed by the learned court in session of the matter, which shall also contain a condition that any violation of public deviation from any of the terms and conditions that would be imposed shall result in filing of petition for cancellation of bail by the law enforcement agency. जेरस करी रखी दी था आपनकर ये पैनल परे फिर खोजले मिलिबन जदी फिर प्रॉब्लम रे पड़िबा
40 plus please the offense initiated against the present is 392 minor.
You are Mr. Swain
Bola.
Mr. BK Bola. Mr. BK Bola for the petitioner, Mr. Standing counsel for the state. Yes, 392 re kete maximum punishment kete?
10 years.
10 years. Yes.
Charge sheet fine.
Past allegation ta verify hela?
Yes, my lord. It is reflected in the charge sheet, my lord. What the affidavit has been given.
Okay.
So that has been fortified by the
age of the petitioner?
40 years.
କେବେଠୁ profession ରେ ଅଛନ୍ତି?
On the 13th
2017 ଅଛନ୍ତି। ସବୁ ଥରକ ବେଲ୍ ରେ ଯାଉଛନ୍ତି।
Those three incidents are related to 2014, 17. And similar, all are similar.
17 ରେ जो incident ହେଲା ବେଲ୍ କେବେ ପାଇଥିଲେ? ତା ପରେ ଏଟା କଲେ ଆଉ ଥରେ 21 ରେ ବହୁତ ଦିନ ହେଇଗଲା ବୋଲି ନା को। Mr. Standing counsel लिखले, the learned counsel for the petitioner submits that the petitioner is in custody since 13/7/2023. The final prosecution report has been submitted on so and so date.
31.
The petitioner being and the petitioner should be shown indulgence as far as prayer for bail is concerned. It is submitted that though in terms of the affidavit filed on behalf of the petitioner through his father, the petitioner has past allegations against him as far as criminal activity is concerned. But petitioner should be given a chance to come back to the mainstream of the social life. Para. It is further submitted that the petitioner, being a local person, shall subject himself to the jurisdiction of the court in session of the matter and shall abide by all such terms and conditions that would be imposed for grant of bail. The learned standing counsel, referring to the materials contained in the case diary and the past allegations against the petitioner opposes the prayer for bail. However, however, it is stated that the information furnished in the affidavit on behalf of the petitioner is in sync with the police report.
Yes.
Contained in the case diary. Having heard the learned counsel for the petitioner and the learned standing counsel for the state, the court is inclined to grant bail to the petitioner subject to such terms and such stringent terms and conditions that would be imposed by the court in session of the matter. We shall also include a condition that any violation of public deviation from any of the terms and conditions shall lead to filing of petition for cancellation of bail by the law enforcement agency, /informant, /victim.
Charge sheet 31/8.
That charge sheet date 31/8/2023.
Item 41 in the same case for the another accused persons.
Antecedent?
7 and
7 antecedent, my lord.
Since 2017. 379.
Yes, my lord.
I'm good. I'm just
2008.
Same order, got a condition likhibe, there shall be a family member of the petitioner shall stand surety for grant of bail.
Let's say 18.
A family member will stand surety
Yes.
for grant of bail.
7-8 बार बोला.
Baki to rahibo that any violation of deviation from. Yes. Yes.
Item 42.
In both cases, since the same case, Mr. the standing counsel, the date of submission of FPR is same.
Yes.
31/8.
Yes.
Okay. Mr. Joyadeva Behra for the petitioner, Mr. Standing Counsel for the state.
For my lord, 1 week time, my lord.
164 ଟା ପଢିଦେଲେ କି ସେଠି ବସି ପଢୁଥିଲେ ନା?
ନାଇଁ ନାଇଁ ଆଜ୍ଞା ମୁଁ ପଢିନି ଆଜ୍ଞା।
ଠିକ
କିନ୍ତୁ
ଅଛି।
ଆମର ସମ୍ପର୍କ ଥିଲା ବହୁତ ଦିନ ହେଲା। ଆମର ପ୍ରାୟ 5 ବର୍ଷ ହେଲା ସମ୍ପର୍କ ଥିଲା।
ଠିକ ଅଛି। ନା ଆପଣଙ୍କର ତ ମିଷ୍ଟର ଷ୍ଟାଣ୍ଡିଂ କାଉନସିଲ ସାଙ୍ଗେ ସମ୍ପର୍କ ମୁଁ ଦେଖୁଛି 22-23 ବର୍ଷ ହେଇଗଲାଣି, ଆପଣ କଣ 5 ବର୍ଷ କହୁଛନ୍ତି?
ନାଇଁ ଆମର ସମ୍ପର୍କ ଭାଇଙ୍କ ସହିତ ମୋର ପ୍ରାୟ
ସେଇଥିପାଇଁ ତ ଆପଣ ପଢି ଦଉଛନ୍ତି ଯାଇକି ସେଠି।
ଆଜକୁ ପ୍ରାୟ 5 ବର୍ଷ ହେବ ମୁଁ ଆମର
ମିଷ୍ଟର ଜୟଦେବ ବେହେରା ଫର ଦ 1 week time.
ଆଜ୍ଞା ଟିକେ।
Jaydev Behra for the petitioner, Mr. Standing Counsel for the state. The learned counsel for the petitioner seeks accommodation to advance arguments as spread for this term. 14 December.
ଆଜ୍ଞା।
December ମାନେ ସେପଟ calendar.
ଆଜ୍ଞା ଆଜ୍ଞା।
14 December 2023. The learned standing counsel submits that case diary is available.
164 time
including the statement of the victim recorded under section 164 CRPC. Yes.
43.
Mr. A.S. Pal, Amlan Shakti Pal for the petitioner. Mr. S.S. Mahapatra, AC for the state. Yes, Mr.
May I please? Lord, last occasion I have filed a
Affidavit. Copy served.
Yes, my lord. Of the sister of
The instruction matches with your.
No, my lord. In this case, the case diary received, my lord, is a wrong case diary, my lord.
Oh.
Instead of Nayagot PS, it has been received from Ranpur PS. I'll be getting the entire case diary, my lord.
Also, you obtain instruction from in response to the affidavit.
Yes, my lord.
Because if that has gone to a wrong PS, then again there is a problem.
Yes, my lord. I have to, because it has to be corrected. The wrong CD has been wrongly intimated and wrong CD has been received. I have already discussed with
Yes.
the
Mr. Mahapatra Lekhle. The learned counsel for the petitioner submits that he has filed affidavit on behalf of the petitioner in terms of the earlier order dated
6/11.
6/11 पूर्व भी ଗୋଟେ order ଥିଲା actually. 12/10/2023, reiterated on 6/11/2023. The Standing Council submits that inadvertently the CD was called for from another police station not concerned with the present matter. Therefore, he may be granted further time to obtain the correct case diary and response to the affidavit filed on behalf of the petitioner. Para. List on how much time?
Only 10 days time.
As per for list on 6th December 2023.
Madam.
The up-to-date case diary along with response to the affidavit be obtained. Yes. Yes. Password डाकी दियंतु.
Password 35
फाइल टा देखांतु 35 फाइल टा. अपन टिके करेक्शन करे पड़ो. अपन जस्ट 50 शीट को पढांतु. Report. '23. Certain directions were issued for intimating the additional district judge come special court.
Kindly see.
खाली 498 अच्छी तांका against है. माने आपण submission कौन सेटा कोंतु आपण I don't appreciate this.
That clear evidence of statement of the witnesses, one statement of the witnesses, family members of the deceased, my lord, parents. They says allegation of demand was there frequently and subject.
Their presence
is their presence is there.
Their presence is there.
Petitioner sustained injury. My lord, while the injury sustained on his hand, my lord, while he says his evidence is while recovering, he got injuries. But that is subject matter of trial. My lord, when she was burned by pouring kerosene, and it is, my lord,
the jerry can and everything has been seized.
My lord,
that plastic jerry can which was carrying this kerosene or petrol.
No, that is not seized, my lord. That is not there.
No, by now, what other evidence is there?
Other evidence, my lord, he.
आपण ताले Mr. Sir, you are खोजचोंदी कोन evidence खोजचोंदी आपण जोटा कि कोजन किछि नाही बोली.
Sir, there is no single evidence against the accused person regarding the my lordship final
like the CCTV footage, Mr. Standing Counsel.
No, my lordship. No, my lordship.
You want?
My lordship, during investigation by the police officer, कौन सी भी जगह रे मेंशन है ही नहीं जे ये केरोसिन नहीं पोड़ी देला ये नहीं कि झरका दे देला इंसिडेंट हैला किछि माइ
सेटा सर एथिरे से हे प्रकार ऑफेंस सेटा कोठी भी न थाए को कोर्ट भी खोजंतिनी. आपण देखंतु आपण कोनोसी केस रे कन्विक्शन रे एटा खोजा जाईछि.
माय लॉर्डशिप
सर एटा खोजा जाय नि सेतिरे.
माय लॉर्डशिप
overt act of the person accused by carrying pouring kerosene and then lighting a match stick. एटा कोन एतरे दरकार हुए.
माय लॉर्डशिप इनक्वेस्ट रिपोर्ट रे भी ता हस्बैंड माय लॉर्डशिप से स्टेटमेंट देई जे भीतर पटु झरक कबाट देई मो स्त्री देहरे केरोसिन ढाली होई.
That is his plea, but it is within their knowledge and within their house. 104 clearly attracts the presumption of their implicating in 304B case.
Examination कौन हेलानी सेटा पचार आपण किछि कहू नांती. पीडब्ल्यू किछि कहलेनी कि
माय लॉर्डशिप स्टार्ट हेनी
तो अपेक्षा करंतु.
My lordship, kindly, my lordship, allow.
And what about the victim? What about the victim who has died?
My lordship.
304B रे,
my lordship.
302, 304 सब लिखा है सब जाननी सेटा हम ऑफिस रे लिखथेबे. सेतरे तर victim रो कोन किछि नाही माने what is the response of the society
ଅଛି my lords.
Because I'll give, because you are saying that the court has to, you are showing the court nothing is there. What else will be there? ଆପଣ ଖୋଜୁଛନ୍ତି କଣ କୋଉଟା ନଥାନ୍ତା ଯୋଉଟା?
Direct evidence my lords is
କେମିତି ଆସିବ unless it is like a open here or like a CCTV footage.
my lords FIR ବି ସେମିତି statement ନାହିଁ 160 वाले ବି ସେମିତି allegation
ଯୋଉମାନେ FIR ଦେବେ
torture submission is there.
are they the eyewitness? ଆପଣ ବୁଝି ପାରୁନାହାନ୍ତି ମୁଁ କଣ ପଚାରୁଛି ଆପଣ ଭାବୁଛନ୍ତି ବୋଧେ ଯିଏ FIR ଦିଏ it can be lost by you also by listening from somebody it sets the ball in motion.
my lords
ଆପଣଙ୍କର FIR ର nature as you said very correctly it's not a substantive evidence anyone can lodge FIR.
my lords
So FIR is not a substantive evidence ଯୋଉଥିରେ କି it will be details of the you will be there because that is also ତା ମାନେ କଣ ହବ ନା FIR ଯଦି ଆପଣ substantive କହିବେ that goes against the accused also. Somebody written something without any evidence. So it is a matter of investigation.
my lords
Investigation charge sheet ଦିଆ ହେଲାଣି ତ
my lords
so we wait for some time.
charge sheet ବି my lords ଯେତେବେଳେ ସେକେଣ୍ଡ ଅଛି
498-304 ରେ ଏମିତି କେମିତି କହିଲେ ହବ ଯେ ସବୁ କିଛି ନାହିଁ ଆପଣଙ୍କର ଇଏ ନାହିଁ so
my lords ଖାଲି ତା ମା କୁ ଆରେଷ୍ଟ କରାଯାଇଛି ଯେ she is the dowry article from the district mother in law ଦୁଲା ବିବି
ତାଙ୍କ ବୟସ କେତେ
52 my lords
age 52 କେତେ ଦିନ ହେଲା ରହିଲେଣି
my lords 6 months 21 days accused number 2 my lords.
Yes Mr. Mahapatra she is a lady
lordship may consider.
Are you sure she 6 months will date of detention kete
6 months 21 days my lords the custody in 1/5/2023 1st May 2023 my lords.
Has she been injured also in the incident?
No my lords at the time
yes,
she was not there.
See he is injured what petition no petition number 2 is not injured.
No my lords.
Why mother is not injured?
My lords
because you see when you said the injury sustained that cuts both the ways that also implicates the person maybe it was when he got injured accidentally because he was actively participating in the burning. Because upon the flammable material is highly petrol is highly flammable even kerosene. But there is every possibility of somebody pouring petrol on somebody and lighting a match he himself will be getting cutting when he'll catch fire.
Catches fire
only allowed lady accused
ଆଉ ଅନ୍ୟ କେହି male members ନାହାନ୍ତି ଘରେ
ଅଛନ୍ତି ଦିଅର
ଅଛି ସେ injured ହେଇକି my lords
second brother of the
sorry injured ସୁବିଲାନି କଣ ହେଲା
my lords ସେ ଉଦ୍ଧାର କଲା ବେଳେ ପୋଡି ଯାଇଥିଲେ ସେ ଆଜି ପର୍ଯ୍ୟନ୍ତ ଟ୍ରିଟମେଣ୍ଟ
brother also ଦିଅର ବି
but not accused.
No he is accused he is also one of the accused.
So ତାଙ୍କ ବେଲ୍ କଣ ହେଲା
ତାଙ୍କ ବେଲ୍ ର condition my lord that statement must be there.
ସେ my lords anticipatory bail already release ହେଇଛନ୍ତି ଏବଂ ତାଙ୍କର ସାରେ my lordship ସେ accused ର ନା କାଟି ଦିଆଯାଇଛି only 2 person alleged
ମାନେ he is not a charge sheeted accused ନୁହଁ ସେ ଏହା କହୁଛନ୍ତି
my lordship
charge sheet ଦେଖେଇଛନ୍ତି ତାଙ୍କୁ ଆପଣଙ୍କ ପାଖରେ charge sheet copy ଅଛି କି Mr. Mahapatra?
My lord yes my lord charge sheet is there. Rehmat present petitioner
Sheikh Rehmat is there.
Yes my lord
he is the present petitioner.
Yes
opposite the second petitioner is
Dulo bibi
ha Dulo bibi ଆଉ ବାକି ଯୋଉ କହୁଛନ୍ତି
open
जो अच्छा late Sheikh Sattar अच्छा the father-in-law is not there.
my lord
चार्ज शीट रे आंकर ना नाही आर दियर न तांका बेल देखियो पड़ियो कि देले कोठी देले से कहउछन एंटिसिपेटरी बेल हे जैतला बोली अच्छा ट्रीटमेंट हेतला ये डाइंग डिक्लेरेशन
no my lord she was found dead from the spot then taken to
से लिखले पारा 2 देखिले पारा 2 पेज 3
my lord UD case was registered
एटा मु गोटे अन्य को केस देखछि की
lordship
9461
my lords
पेज 3 देखंतु पिटिशन रा पेज 3 पारा जस्ट अबव पारा 3
पारा 2
yes पेज 3 को जिबे पारा 3 रो ऊपर At last the deceased died during the treatment, her treatment at SCB Medical.
Yes, my lord. She was while undergoing treatment.
So the dying declaration would have been
से UD case କରିଦେଲେ ମାନେ ସେଇଟା ଯୋଉ death ହେଲା ସେଠି
usually when the person is critically injured,
that case is that is there, my lord. UD case report is there, my lord, with me.
ତାଙ୍କର କିଛି record କରାହେଇନି statement 161 dying declaration.
ନାଇଁ କିଛି କରନା.
How is it possible? ତ ମାନେ lackadaisical investigation.
While she was brought to the hospital, my lord, during treatment, doctor declared dead on 6/4/2023 at 10:25 p.m.
So the incident occurred on 1/4.
1/4.
So you verify her statement. What is her statement?
That has not been, my lord.
You ask the investigating officer and the circumstances why they have not recorded.
Well, ସେ ଆସିଲା my lord 1 ତାରିଖରେ.
Yes.
It was after death it was reported to the police because
no ଆପଣଙ୍କର ହସ୍ପିଟାଲ ରେ ରେକର୍ଡ ହେଇଯିବ.
ହସ୍ପିଟାଲ ରେ ଏଣ୍ଟ୍ରି
ହସ୍ପିଟାଲ ରେ ତାଙ୍କ କ୍ରିଟିକାଲ କଣ୍ଡିସନ ଥିବ. କେତେ % ବର୍ନ ଥିଲା କି
1 ତାରିଖ ଦିନ
ବର୍ନ ର କେତେ % ଥିଲା?
my lord, I am seeing the postmortem report. External injury.
ଯେ ଏଫଆଇଆର ଦେଇଛନ୍ତି ସେ କହୁଛନ୍ତି ଯେ ସେ ଆଣି ତାକୁ ଚିକିତ୍ସା କରେଇଲେ.
Percentage of burn injury, my lord, is not given, but in the
%.
yes, ma'am.
So 55% burn injury means they would have recorded statement. Yes.
Then say FIR decision, lordship, kindly have a glance to the page 11.
The above mentioned external injuries are antemortem in nature. ଆପଣ ଯଦି ତାଙ୍କ ପିଟିସନ ରେ ପେଜ 41 ଦେଖନ୍ତୁ.
My lord.
Could have been caused due to exposure to dry heat, so the flames or fire. So
yes, ma'am.
So antemortem ये injury, intentional injury by burning. So upon just kindly check the statement.
Statement, lordship, kindly have a glance to page 11, the FIR.
FIR I have read, but this is a case from SCB Medical College.
Yes, my lord.
So where it was first reported, who has recorded the statement? Just try to verify.
My lord.
So UD case has been registered in medical SCB,
yes,
where she was undergoing treatment.
Yes, ma'am. Casualty entry is, my lord, memo number 32 dated 1/4/2023 from Dr. P.L. Chand of AC Medical College regarding the death of Nirsa BP. Admit
so ଆପଣ ଯୋଉଟା 161 statement ଏତେ investigation ବି କାହିଁକି ଏମିତି କରିଛନ୍ତି ମୁଁ ବୁଝି ପାରୁନି. They don't seem to be very influential people, ମାନେ ସାଧାରଣ ଲୋକ. 161 statement କୋଉଟାରେ ଆପଣଙ୍କ ଫେଭର ରେ କହିନାହାନ୍ତି ସେ କିଛି 14 ରେ ଲେକ୍ଚର. 14 रे victim page annex 2 रे victim रो कोटा 161 statement
victim are deceased. Tar statement.
I'm sorry, yes, deceased and victim.
And FIR registration is after her death. While undergoing treatment, my lord, I have to obtain instruction whether she was examined by the police or not, or any information was given by the medical authorities to the police or not. That doesn't reveal in the UD case record.
Usually, in these kind of matters, medical legal cases, they'll inform. Because that's part of the standard protocol.
Yes, yes, ma'am. Married lady and also the family members must have.
Mangalabag police station, UD case.
UD case is of my lord, that SDM, sub-divisional magistrate. That is of Kotak, Mangalabag, order Mangalabag police station.
You see the order of rejection, it refers to the statement of the victim also.
Yes, yes.
The deceased. You obtain those details.
But here in inquest
Mr. Ita kitna number item? So you are Mr. Behra. Mr. Niranjan Behra for the petitioner. Mr. S.S. Mahapatra AC for the state. The Lord Counsel for the petitioner submits that shall I mention that you are not right now not pressing for petition number 1 or I do next date dekhiba theek ache. The Lord Counsel for the petitioner submits that in the meanwhile the charge sheet has the final prosecution report has been submitted on
2 persons. One is
date ta kontu
5th 2023 5 August
5th of August 2023 and the petitioner are in custody since
let's see
1-5 रो छंती
आगे 1-5 2023 accused number 2
Mr. Mahapatra.
Hello.
Then they have lost complaint on 1-5. The police should have started investigation on 1-5.
Yes, ma'am.
Because the person was alive. The person was alive, so obviously after death, UD case is registered in Mangalabag.
Yes.
It is very unfortunate if the police has not recorded the statement of the victim and we see is only there is a burn of 55%. She is fit to talk. Even 80-90% one is fit to talk. Unless the face portion is burnt. The Learned Standing Council, the Learned Additional Standing Council 6 shall obtain up-to-date case diary and instructions. And in particular, if statement of the victim has been recorded in the form of dying declaration, /164 statement, /161 statement before her death. You लिखिए 164 and CRPC लिखते. Yes. When do you want, Mr. Mahapatra? How much time? How much time?
Oh, only 7 days time.
आज कितने तारीख है? 22. List on 1-12 आज prayed for. Yes.
Item 46.
Petitioner number 1 is not pressed.
Bottoman Korantul. Because there is a possibility that she has herself stated something which has, I'm really surprised.
Yes.
The matter is reported on 1-5. They are arrested on 1-5.
Yes.
Then still the statement is not recorded. It would have been different because suppose till the death happened, the UD case is registered. No investigation was started. That's another thing.
Yes.
But here because he says from upon sure to 1-5 arrest hitile bole 1-4
my lord husband arrested hela my lord 9-4
se koi paribeni seta kintu there is 1-4 re void memo number it has been of AC medical she was admitted and she died on 6/4
ne arrest କଥା ପଚାରୁଛି arrest କେବେଠୁ ହେଲା
9-4-2023 ରେ my lord ଶିବ husband arrest ହେଲେ ତାଙ୍କ ଶାଶୁ arrest ହେଲେ 1-5-2023
ସେ FIR ରେ ଦେଇଛନ୍ତି 7 ତାରିଖ ରେ ମାନେ
7-4 ନା 5?
7-4.
So there I got confused.
after.
Anyway, तथापि आपण instruction आणନ୍ତୁ. Yes, next.
May please, Lordship.
केते number item एटा?
Item 46.
46.
You are Mr. Lenka.
Ma'am.
Mr. S.K. Lenka for the petitioner. Yes.
The petitioner is custody since 24th July 2023, Lordship. In the meantime, final pair has been submitted and 72 grams.
There is only one antecedent, Mr.
Ma'am.
Mahapatra.
One antecedent. One antecedent.
ଆପଣ ସେଇ 120 ଗ୍ରାମ
Lordship, 72 grams.
72 ଠିକ ଅଛି.
Rather in CD, there was no instruction of criminal antecedent. They had denied. There is no adverse. But he on affidavit.
The standing counsel has thanked his colleague. You also thank your colleague.
The mechanism is
Mr.
A long trend has developed.
Mr. Likhile, appearance. Mr. Jesus Mahapatra, the learned counsel for the petitioner submits that the petitioner is in jail custody since 24/7/2023. The final prosecution report has been submitted on date ta kohunanti jaldi tik karantu 24/9/2023, and the petitioner may be shown indulgence as far as the prayer for bail is concerned. Stop Sapara. It is submitted that the petitioner is being a local resident, shall subject himself to the jurisdiction of the learned court in season of the matter, and shall abide by all the terms and conditions that would be imposed for grant of bail. The learned ASC, referring to the materials contained in the case diary, as well as the provisions of section 37 of the NDPS Act 1985, opposes the prayer for bail. What is the age of the petitioner?
28, let's say.
Having heard the learned counsel for the petitioner, the learned standing counsel, the learned additional standing counsel, and considering the age of the petitioner being 28 years, and considering the fact that the petitioner should be given an opportunity to come back to the normal social life, the court is inclined to grant bail subject to such stringent terms and conditions that would be imposed by the learned court in season of the matter. We shall also include a condition that in case of any violation of oblique deviation from any of the terms and conditions that would be imposed for grant of bail, the law enforcement agency shall have the liberty to file a petition for cancellation of bail, disposed of accordingly. Yes.
May I please, my lord?
Yes, please.
This is a case under section 376 2N 294 323 506 and 34 of IPC. Read section.
आपण सेक्शन पढन्तु नि दरकार नै. आपण वर्तमान भारतीय दंड संहिता आसले फेर बदल जियो सब. 302 टा कोन अछि? इतरे नुआ ए रे कोन हैछि 302?
302 300
case of 376.
से वर्तमान सेक्शन जो पढुं सेटा चेंज करंतु कना आउ सेटा हबनी हो किछ दिन परे. You are appearing for the informant.
Yes, my lord.
Yes. What do you say?
My lord, by instruction of the victim that they have good relation with the appellant. In the bail application statement, the victim also stated that he has no objection on the bail petition of the accused person.
Statement achi. Mr. Mahapatra?
My lord.
You are having the statement?
No, my lord, the 164 statement and a charge sheet copy. Charge sheet must have been filed in the meantime. That has not been. Only case day received, my lord, without charge sheet. Much before.
The charge sheet already filed.
Mr. Panigrahi, it is.
The charge sheet is filed later. Meanwhile,
you have 164 statement.
Yes, my lord.
Shall subject himself to the jurisdiction of the court in session of the matter, and shall abide by the terms and conditions that would be imposed for grant of bail. The learned standing counsel, referring to the materials contained in the case diary, opposes the prayer for bail. The learned counsel, appearing for the informant, referring to the case diary and statement of the victim, opposes the prayer for bail. However, regarding the filing of the charge sheet, there is no dispute at the bar. This court has occasion to go through the statement of the victim recorded under section 164 of the CRPC by the learned magistrate, that was produced at the virtual court, that was produced at the virtual court, Koraput at Jaipur, and screen shared in the VC. Para. Having heard the learned counsel for the petitioner, the learned additional standing counsel, and the learned counsel for the informant, the court is inclined to grant bail to the petitioner, subject to such terms and conditions that would be imposed by the learned court in session of the matter. We shall also include a condition that any violation of oblique deviation from any of the terms and conditions that would be imposed for grant of bail shall result in filing a petition for cancellation of bail by the law enforcement agency, disposed of accordingly. Yes.
49.
Mr. Suresh Kumar Jenna for the petitioner, Mr. S.S. Mahapatra AC for the state. Yes, Mr. Jenna.
Next one.
Mr. Jenna, the learned counsel for the petitioner submits that seeks accommodation to advance arguments as paid for list on 12th December 2023 to grant further opportunity to the petitioner. The case diary has been received, Mr.
Yes, my lord.
The learned
Charge sheet has been issued.
the learned 6-12 2023 कर दियो तो 6-12 the learned AC submits that he has received the up-to-date case diary, which includes the final prosecution report.
Yes.
Yes.
30.
Mr. Sarada Prasad Das for the petitioner. Yes.
File the affidavit.
The learned counsel for the petitioner submits that. Sorry, sir. Mr. Sarada Prasad Das, Mr. S. Sridhar Das for the petitioner, Mr. S.S. Mahapatra AAC for the state, learned counsel for the petitioner submits that upon affidavit court re kebe file kale.
File करने आज ये पे कर दे rest.
That submits that he shall file affidavit on behalf of the petitioner indicating the past allegations of criminal activity, comma, if any. Registry shall update the same. Registry shall update the case brief. Scan copy of the case brief. Para. Copy of the affidavit has been served on the learned ASC, who shall obtain instruction. How much time, Mr. Mahapatra?
10 days time.
As spread for list on 4-12-2023.
Third of December.
Third week रखे पे कुछ
11, 12
on 12-12-2023. सेटा थर्ड वीक नु सेटा आपण गोटे 1 तारिख टा गोटे वीक बोली धरचोंदी सेटा सेकंड वीक बट जेतो बेबल जणा पड़ेनी एक्चुअली व्हेन द लास्ट डेट इज इटसेल्फ इज 1st of December. Yes. 12
51.
On behalf of Mr. Mahanti, taken up 2 weeks after.
आपन का नाम सर?
D.R. Misra.
Power 9. So D.R. Misra on behalf of P.K. Mahanti for the petitioner. तो मेंशन करथिले ना कोन? जे समतरे मेंशन करथिले.
आगुरु टाइम नहीं.
The learned counsel for the petitioner seeks accommodation to advance arguments as spread for list on 5th of January. केबे चाहउछंदी मिस्टर?
50.
15 December 2023 December ଆପଣ ଯୋଉ ଲେଖିଲେ accommodation ନୁହଁ 6 accommodation 6 further accommodation ଲେଖିବ listen 15 12 ତାପରେ ଲେଖିବେ the Lord ASC submits that case diary is available କେତେ କିଲୋ କି ଏଥିରେ
519 କିଲୋ
519 କିଲୋ ଆଉ ତାହେଲେ ତ ସେ ଠିକ ଡେଟ୍ ଦେଇଥିଲେ ଆପଣଙ୍କୁ ଜାନୁଆରୀରେ
ଡିସେମ୍ବର ସେଇଟା ଥିଲା ଜାନୁଆରୀ
ଠିକ ଅଛି ଆପଣ 519 କିଲୋ ସାର୍ କହିଛନ୍ତି ଟିକେ ମହାନ୍ତି
ନା ମୁଁ ଜାଣିନି
ଏକ୍ସାକ୍ଟଲି
ତାଙ୍କ ବାପା ଚାଲି ଯାଇଛନ୍ତି ସେ ଗାଁରେ ଅଛନ୍ତି ଆସିନାହାନ୍ତି ଜାନୁଆରୀ
ସୋ ଯେ ସାମନ୍ତରାୟ ମେନସନ କରିଥିଲେ ନୋଟେଡ
ଜାନୁଆରୀ
ନାଇଁ ନାଇଁ 519 କିଲୋ ମୁଁ ଶୁଣିକି କହୁଥିଲି ଯେ ସେଟା କାହିଁକି ଆପଣ 519 କିଲୋ ଆଉ କଣ ହବ ୟେସ୍
52 May please, madam. Can you take 2 weeks?
2 weeks sir ଆପଣ କଣ କଟକ ଛାଡି ଭୁବନେଶ୍ୱର ପଳେଇଲେଣି Mr. You are Mr. Swai, Mr. M.K. Swai, Mr. Malay Kumar Swai for the petitioner, Mr. S.S. Mahapatra AC for the state, the Lorded Counsel for the petitioner being present at the virtual court, Khurda at Bhubaneswar, addresses arguments. The Lorded Counsel for the petitioner seeks further accommodation to advance 6 further accommodation as paid for list on 18 December 2020 again second week कहले 14 12 20 23 और फर्स्ट वीक माने होची 4 सेकंड हला 11 सो एफसे डाकत 14 12 The Learned ASC submits that case diary is available.
Only criminal antecedents have to bring.
And he shall obtain the past allegations against the petitioner
by that date.
By the said date, comma if any. Past allegations, comma if any, by the said date. Yes, next.
53.
So Nityananda Mahapatra for the petitioner.
On the request of counsel N. Mahapatra, I am appearing.
Yes.
Appearance memo. The charge sheet though is available. It's a case under section 302 with the allied offences. Though the charge sheet is with me, but the PPM report, that is the autopsy report, is not there. And
so you get, if at that stage in case of a 302 matter, then you have to go through that. Or if there is any examination of any PWs, which may help.
It's a trial has not yet commenced. Only that.
No, I am not saying that it has commenced, but you have to wait for that. There can't be any hurry in these matters as far as grant of bail is concerned.
2 weeks time. 2 weeks time, madam. Yes, madam.
Mr. R. Mahapatra submits that Mr. R. Mahapatra along with Mr. N. Mahapatra for the petitioner, Mr. S.S. Mahapatra for the opposite party. ଆପଣ ସାର୍ ଆଜି କି ମହାପାତ୍ର ନାହାନ୍ତି କି ଠିକ ଅଛି so S.S. Mahapatra AC for the opposite party. The Learned Counsel for the petitioner submits that he may be accommodated to obtain instruction and advance arguments as prayed for list on 15th December na kebe chahunchandi sir 18th of December 2020 yes 18th of December 2023 the Learned ASC shall obtain up to date case diary obligation. The Learned ASC submits that a case diary is available and he shall obtain up to date instruction. Yes. Upon case diary PM report अच्छी कौन?
Yes, madam. PM report.
Okay. ठीक है. The appearance memo of Mr. Mahapatra shall be taken on record. Scan copy भूल ही गला. भूल नंबर पड़ेगा एटा करेक्ट कर दियंतु एटा रॉन्ग फाइलिंग रे पड़ेबो नंबर भूल अछि त लिखले टेकन ऑन रेकॉर्ड स्कैन कॉपी भी अपडेटेड यस नेक्स्ट ठीक है
54
चलियो तो से अपियर करछु
May please, Lord.
तो महापात्र आल्सो बी इंडिकेटेड इन द कॉज लिस्ट कर देबे
May I please, your lord? Item number.
Just a second. Mr. Manoj Naik for the petitioner, Mr. S.S. Mahapatra AC for the opposite party. Hybrid mode लिख The learned counsel appearing for the petitioner being present at the virtual court, Odisha High Court, Khurda, at Bhubaneswar, addresses arguments. Yes, what do you say, Mr. Naik?
Well, I will also directed to submit the affidavit. One affidavit is filed by his father before the court regarding the 22 antecedents.
Throughout Odisha, Ochi. Affidavit copy has been sent by mail. Have you received copy?
No, I have drawn it from our.
Mr. Naik, लिख ले, appearance लिख ले, SS Mahapatra लिख ले, order लिखो advance arguments लिख ले, being present at so and so. It is submitted by the learned counsel for the petitioner that the copy of the affidavit filed on behalf of the petitioner through his father has been forwarded to the office of the Advocate General by email. The learned additional standing counsel submits that he has received the copy today in court and shall obtain instruction. In response to the same. How much time, Mr. Mahapatra?
1 week time.
As prayed for, list on 4/12/2023.
I'll talk to the up-to-date case diary, my lord.
The up-to-date case diary. ଆପଣଙ୍କର status of trial ଆପଣ ଯୋଉଟା list ଦେଲେ Mr. Naik, you have to give the status of trial. ଆପଣ ଖାଲି ଗୋଟେ 1 2 3 4 କରି ଦଉଛନ୍ତି. ମାତ୍ର 22ଟା କେସ୍ ଅଛି ଫେରେ throughout the state. ଆପଣ instruction ଆଣିବା ବି difficult ହବ କାରଣ so many places ସେଟା ଅଛି. ଢେଙ୍କାନାଳ, ଭୁବନେଶ୍ୱର, ମାଲକାନଗିରି, ଯାଜପୁର,
Puri,
ଚାନ୍ଦବାଲି.
He has to give the details of those cases, my lord.
ଆପଣ details ନ ଦେଲେ ସେ ହବ କେମିତି? That is responsibility of the petitioner or for the prosecution?
Veteran criminal, my lord, he has started from his juvenility and
ଆପଣ 13 ରୁ 23 ଭିତରେ ଆପଣ 22ଟା କେସ୍ and as many as some 10 places. The learned counsel for the petitioner shall also obtain instruction and file affidavit if so advised regarding status of each of the cases mentioned in the list submitted by mentioned in the affidavit filed by the father of the petitioner dated 7/11/2023. See, ଗୋଟେ dash କରି ଲେଖିଛନ୍ତି compromise bail ଲେଖିଛନ୍ତି custody. ସେଟା ଦରକାର ନାହିଁ. ସେ par line କାଟି ଦିଅନ୍ତୁ. ସେ simply ଗୋଟେ dash ଲେଖି ଦେଖି ଦେଇଛନ୍ତି closed on bail. Then ଏଟାରେ short date ରେ instruction ଆସି ପାରିବନି. ଏଟା କେବେ date ଦେଇଛନ୍ତି?
4/12.
The instruction be obtained by 8/12 list on 12/12.
Obliged.
ରହିବ ନାହିଁ. ଦେଖାଯାଉ ନାହାନ୍ତି. Mr. Naik, your matter will come on 12/12, 12th of December, Mr. Naik. Mr. Tripathi, 55 also.
Here in this
Pramananda Tripathi, Mr. Pramananda Tripathi for the petitioner, Mr. S.S. Mahapatra, AC for the state, the learned counsel for the petitioner being present at the virtual court, Odisha High Court, Khurda at Bhubaneswar, addresses argument. The postal requisites, এটা কোন peremptory order ଥିଲା কি Mr. Tripathi?
No, simple order was issued and I have complied.
As directed by earlier order of this court, it is submitted. ଆପଣ କାଟିକି ଲେଖନ୍ତୁ ଆଉଥରେ ମୁଡୁଲେ. It is submitted by the learned counsel for the petitioner that due to inadvertence, the requisites for issuance of notice in the limitation matter could not be filed.
It was filed.
And further time may be granted for filing of the same. Para. Prayer is allowed. Let requisites for issuance of notice by registered post with AD be filed within 2 weeks. List after SR. Notice टा कौन लिखे लिमिटेशन लिख ले ना नहीं हाँ yes
56
54 टा 12 yes let the report be obtained by 8/12 list on 12/12 कटिगला 2 weeks time granted Mr. Tripathi. Now you have been disconnected. Let us see.
Immediately after the order was passed, I submitted it.
नहीं से ऑफिस नोट जदि आपण चाहउछन्ती भूल अछि आपण वेरीफाई करंतु सेटा मु कहि परिबे नेबे because there is a clear noting that postal liquid is not filed.
माने हम देजर 80 टा फाइल कर दियो.
नहीं सेटा नहीं सर आपण you go to the registry and reconcile. आपण don't ask the court to reconcile that. I am not able to hear you clearly, but if I have understood that if you have filed it already, then you can always reconcile that. But I can go beyond the noting. The noting is not filed. I have to stick to that. If you want anything, then you can reconcile. Or after this, you have filed notice because it is noting is today. आपण फाइल करछन्ती बोली कहउछन्ती ना कोन एक्चुअली मु आपण सुनी पारुनी
जो दिन ऑर्डर टा हेतला तर 3-4 दिन पर फाइल करछ रिक्विजिट्स पोस्टल
अब काटिया पड़ियो ताले ऑर्डर टा काउथे लिखिया पड़ियो 55 तांको डा कहि फाइल टा तांको पळेला आगे अछि उठेटा देबेन से भूल ऑर्डर लिखा जे ऊपर the learned counsel Mr. Brahmanand Tripathi for the petitioner Mr. S.S. Mahapatra ASC for the state. The learned counsel for the petitioner submits that he has already filed the requisites for issuance of notice by registered post with AD. Registry shall verify and do the needful. Upon jai verify karantu, reconcile karantu jodi heitbo. Aye. If tapar lekhandu sapara if it is found that the requisites have been filed, notices shall be issued to the opposite party by registered post with AD. List after SR, service return. Hala. Next.
56.
56, my lord, for Arjun.
Mr. Karna. I'm sorry.
Vikas Karna.
Mr. Vikas Karna for the on behalf of the J.K. Ponda for the petitioner. The learned counsel for the petitioner adjournment is sought for. Adjournment is sought for on behalf of the learned counsel for the petitioner, seeking for the time to remove the defects. As prayed for, further 2 weeks time granted to remove the defects. Defect removal, janchandi da? Please do that. Yes.
57.
Mr. B.R. Mahanti for the petitioner. Mr. S.S. Mahapatra AC for the state. The learned counsel for the petitioner submits that the petitioner doesn't want to proceed with the present matter. Memo dated 22/11/2023 stating the same is taken on record. Para, the petition stands disposed of. Yes, next.
58. My lord, your state has filed this application
for grant of leave, my lord, against the order of acquittal.
Yes. Could you go through the judgment?
Yes, my lord, I have gone through.
Yes.
There is nothing substance, my lord, to.
So
because
apart from not condoning the delay,
yes, my lord.
Apart from not condoning the delay, the petition stands. It's a case where it's not fit for grant of leave.
Case of 492, 304B and 306. The principal witness, my lord, doctor says it is a natural death due to complication in pregnancy.
Oh.
And also the brother.
So homicidal no.
No, that is not, my lord. That.
How can the leave be sought for?
Yes, that while drafting, my lord, I could go through the grounds given. That is also not substantial.
That I understand. I know the constants of a counsel who is entrusted. There are so many things.
Yes.
But this is little bit extreme. When the death is not homicidal, then how? Then
and also the
on what basis the person can be held?
Plea of alibi has also been proved. And also, my lord, the demand has not been proved. Demand, the brother, PW2, he on cross-examination says they were leading a good, healthy matrimonial life.
That has happened in the other day. I remember the PW. In another matter, PW 9 and 10 being brothers, they did not support the prosecution case.
Yes.
Brothers of the victim, they are not supporting. So, here it is still strange that.
That is a good ground for, my lord, acquittal, but that is not a good ground for filing this petition. I have to support the state, my lord.
Yes, obviously. The petition under item 58, Miss Case CRLLP 66 along with Miss Case 49 of 2012. The miscase has been filed. The miscase has been filed for condoning the delay of 26 days.
267 days, madam. 267.
268 days. 268 days in filing the petition seeking leave to appeal. Para. Since after going through the grounds stated in the petition and the objection file, upon objection file kar dichhe and hearing the learned এটা HK Mahanta লিখিবে opposite party ପାଇଁ HK Mahanta. Ground stated in the petition and after hearing the learned counsel appearing for the opposite party, in considered opinion of this court, sufficient ground has not been shown for condoning the delay in filing the petition. Para. Apart from the point of limitation, this court also considers the petition seeking leave on its merit. Para. On perusal of the judgment impugned, it is indicated that judgment impugned as annexed to the petition.
But she may refer to para 10 of the judgment.
सेटा कोठी पाउनी अच्छा सेटा पेज हमर नै पेज मार्क मोर बिल्कुल नहीं मोर सब पेज समान
internal page 7 of the judgment.
It is found that at paragraph 10 the evidence of the autopsy surgeon has been recorded. कोट कर दे para 10. The learned Trial court, apart from considering the evidence of the doctor, as indicated above, has also considered the evidence advanced on behalf of the prosecution to hold that the other witnesses also did not support the allegations made under section 4, allegations of demand of dowry to substantiate a charge under section 498A. Para. In view of the above, the delay in filing the petition is not condoned. Delay of 268 days in filing the petition is not condoned, and the petition is disposed of, not being a fit case where leave can be granted to file appeal. Yes. Then the next matter.
59.
This is the appear cornantio. None appears for the petitioner when the matter is called, though the matter is stop. Appearance likely upare. None, and then State Counsel SS Mahapatra. Though the matter is pending since 2013, notices on limitation were issued on 2/7/2014. Thereafter, further opportunity was granted on 27/10/2014 to file the requisites for issuance of notice within a week. And on 15/7/2015, further 1 week time was granted. No steps have been taken on behalf of the petitioner. Apparently, the petitioner has lost interest in prosecuting the matter. The petition stands disposed of. Yes, next.
60.
Same order. 59/60 Ekka order. Ekka appearance. Yes.
61.
Petitioner done. 61 to waste matter जोड़ा mention है नहीं ताको अपना बड़ा specifically urgent थिला कुछ नहीं कि काली नहीं आसन आज्ञा नहीं काली पे आपण को specific urgent केते टा अछि specific urgent 33 टा mention जोड़ा को तो सरी गला आज close हे गला so आपण total आज list करछन के 88 टा we have gone up to 61 20 टारु धरंतु रहिला आपण को 15 टा 33 plus 15 केते हला in the orders now, but I will not call the list after 4:30 because since that has been mentioned in your matter, I have noted it. The memo you have filed in the court.
I have no.
Achha, you have filed the affidavit by the son, so it is already on record.
That is on record, but the
Yes.
second matter, the tagged up matter, that remains.
Yes, that was a matter of Mr. Digambar Misra.
Yeah.
Have you informed him?
No, I couldn't find him.
अरे अपन तो फोन करिबे ना.
I can call him.
Second matter I am disposing of. No, after passing away of the opposite party, then how it can be maintained by the private opposite party. Mention what I call current.
62.
Mr. Manish Dheer on behalf of Sarthak Naik for the petitioner. Opposite party blank. The learned counsel for the petitioner submits 6 for accommodation. As prayed for. List on 8 January 2024.
66.
Name of Mr. S. Naik be indicated in the chat is already indicated. Yes. Then
66.
Mr. Sangram Das, standing counsel for the state petitioner, Mr. D.P. Patnaik for the opposite party. It is submitted by the learned counsel for the opposite party, also agreed upon by the learned standing counsel for the petitioner, that during pendency of the petition, unfortunately, the the opposite party has passed away. The affidavit filed by the son of the petitioner indicating the same is on record, marked as flag K. Affidavit dated affidavit dated 13/11/2023. Accordingly, the petition abates as against the opposite party, stands disposed of. Yes. Next. Sub-item sub-item of the petitioner none, Mr. D.P. Patnaik. None appears for the petitioner when the matter is called. The learned counsel appearing for the opposite party submits that during pendency of the petition, the opposite party has unfortunately passed away. The affidavit dated 13/11 filed by the son of the deceased petitioner. So again, bhul the deceased son of the deceased opposite party. It is opposite party. Deceased opposite party is on record, marked as flag A. The petition as against the opposite party abates, stands disposed of. Yes, next.
67.
Ms. Saloni Mahanti for the petition on behalf of Amit Prasad Bose for the petitioner. The memo delay.
No, sir.
The learned counsel for the petitioner submits that they have no up-to-date instructions in the matter on behalf of the petitioner. Opposite party pe likhiye 67 Mr. Devasis Naik, AG for the state.
I am for the opposite party number 2.
Mr. Your name, sir?
Sheikh Aziz on behalf of N.K. Das.
Mr. Sheikh Aziz on behalf of N.K. Das for OP number 2. Appearance likhile. Tapare likhibe je that it is submitted likhibe. The petition was filed in the year 2011 under section 401, read with section 497 of the CRPC, seeking revision of the order dated 9/6/2009, passed in 1 CC number 323 of 2008 by the Learned SDGM Sambalpur, taking cognizance under section 138 of the NI Act, Negotiable Instruments Act. In considered opinion of this court, nothing would survive at present, as the order taking cognizance was challenged, that was passed to 12 years back. To state the 9. It's also noticed that no interim order was passed as regards the proceeding pending before the Learned SDGM. SDGM na Sambalpur na of the Learned court na likhiyo thik re. Para. In such view of the matter, the petition stands disposed of. As disposed of likhi do, thik ache.
Item 71.
Or in considered opinion of last line, in considered opinion of this court, nothing survives for adjudication at present before this court. the petition stands disposed of.
My lord, pardon, my lord.
Kitne
Item
draft likely?
69, my lord.
Other matters, don't worry. After 4:30, I am not calling the list.
No, my lord.
These matters were mentioned.
Yes, my lord. My lord.
69 will be listed tomorrow. Add hijoi.
Tomorrow, my lord, may not be because
no problem.
We have asked for the instruction from the petitioner, my lord. It will take some time, my lord. Next week or any other date may be taken up. Not tomorrow.
देखिए आटे सौरू what disturb करंतुनी. Be patient. Since I am not calling the list, so I have to take up the mentioned matters first.
Okay.
पण जदि चाहूचंदी कि adjournment ପାଇଁ ଟିକେ wait करंतु. I am not calling the list. So काली सेटा आपण adjourn कर देले हबो नि जेबे next आसीबो. Adjourn कर देबे कोन? काई व्यस्त काई होचंती. 671 Miss Swedha Ratha, M.S.S. Ratha on behalf of Anupam Ratha for the petitioner. Opposite party, anyone present?
My lord.
Mr. Devasis Samal for the opposite party. The learned counsel for the petitioner submits that they have no instructions to appear on, they have no further instructions to prosecute the matter on behalf of the petitioner at present. The learned counsel, upon instruction kono?
Yes, she has not been paid the dues. That is the instruction, but not a direct instruction through counsel.
Kon kariyo?
Non-prosecution might be dismissed.
Sorry?
Non-appearance, and non-prosecution.
ଆପଣ କଥା ହେଲେ କି ତାଙ୍କ ସାଙ୍ଗରେ?
ମୁଁ କଥା ହେଲି lawyer ସାଙ୍ଗରେ. Lawyer କହିଲେ instruction ମୋ ପାଖରେ ଏବେ ନାହିଁ.
ସେ ବି ଜାଣିନାହାନ୍ତି ମାନେ କଣ୍ଟାକ୍ଟରେ ନଥିବେ, that's the problem.
Right. Conviction ହେଇଛି ପୁଣି.
The learned counsel for the opposite party submits that he contacted the learned counsel who was appearing in the lower court, who was entrusted the brief to him. He also informed that the opposite party is not in touch with her lawyer, his lawyer. Her lawyer.
Lady.
In such view of the matter, the petition stands disposed of. The memo dated 22/11/23 is taken on record.
76.
लिखिबे on 9/11/2023 appearance pare jota likhileni ki on 9/11/2023 the following order was passed after hearing the learned counsel appearing for the parties. That earlier order also I am reflecting, because then also the same thing I granted for the time.
Right.
Yes.
76.
Mr. Amilaratna Ponda for the petitioner, Mr. Devasis Naik AGA for the state, learned counsel for the petitioner seeks accommodation to advance arguments as prayed for, list on 8th January 2024.
80.
Mr. Debaranjan Mahapatra, D.R. Mahapatra for the petitioner. Opposite party, state Tanahanti, opposite party blank. The learned counsel for the petitioner submits an instructions that the petitioner has unfortunately passed away on 22/12/2022 during pendency of the present proceeding. Memo filed by the learned counsel for the petitioner dated 22/11/2023 is taken on record. The petition stands disposed of. Yes.
82.
Mr. P.K. Mallik on behalf of S. Mahapatra, Satyajit Mahapatra for the petitioner. Mr. Standing counsel for the state, learned counsel for the petitioner submits that he may be accommodated to obtain up-to-date instructions and advance arguments. As prayed for, list on 5/1/2024.
86.
Mr. J. Samantray on behalf of M.S.Sahoo for the petitioner. Mr. S.S. Mahapatra AC for the state, learned counsel for the petitioner seeks accommodation to obtain instruction. As prayed for, list on 19/12/2023.
88.
Mr. Himanshu Shekhar Misra, Mr. H.S. Misra for the petitioner. Mr. S.S. Mahapatra for the opposite party. The learned counsel for the petitioner seeks accommodation to obtain up-to-date instructions as paid for list on 9/1/2024. କାଲି ନେଇ ଆସନ୍ତୁ ଆଉ ଥରେ କହିଲେ ଦେବା ପାଇଁ ଯୋଉଡାକ କାଲି କି ପରଦିନ ନହେଲେ ଆଣିବେ କାଲି ନହେଲେ ଆଡ୍ କରିଦେବେ କାଲି ନା କୋଉ ଦିନ ସୁବିଧା ହବ ପରଦିନ ନେଇ ଆସନ୍ତୁ पण ଏବେ ଯଦି ଅର୍ଡରଟା ହେଇଥିବ ତାକୁ ଲିଷ୍ଟ କରିବାକୁ ପଡିବ। ଥ୍ୟାଙ୍କ ୟୁ।